Welcome everyone to the Committee on Judiciary and Hawaiian Affairs in joint hearing with the Committee on Health and Homelessness. Today is Tuesday, February 6th, 2024. It's 2 p.m. We're here in conference room 325, and we're also running this hearing by video conference as well. Thank you, Chair Bellotti, and to your committee for being here, and thank you to my members from Judiciary and Hawaiian Affairs for being here, and my inimitable and excellent Vice Chair, Representative Takayama. Let's go ahead and get started, but I wanted to let folks know that on Zoom, you know, if you have any issues testifying, please, if there are technical issues, you can, you might want to turn the monitor on. If you have any technical issues, just use the chat function on Zoom to communicate with the technical staff. Just use that for technical issues only, technical assistance only. Don't try to text me because I won't get it. If there are any problems with your internet connection, and you drop off, don't worry about it. Rejoin us and I'll try to get you back and testify as soon as we can. And if the power goes off here in the building and we have to reschedule, I'll go ahead and properly notice and send out notification on when we have our next hearing. I ask everyone who is testifying on Zoom not to use any copyrighted image behind you, because that kicks us off of YouTube, and that's a problem. So just use one of your own nice pictures instead of a copyrighted image. And then finally, if everyone would conduct themselves with aloha. Remember, we're all allies here working on behalf of the state, so please, no profanity or don't get upset. You know, it's okay to disagree, but let's not be disagreeable. We're all in this together. I'd like to ask testifiers to keep your testimony to 2 minutes, and I'll ask you to wrap up at that point so we have time for everyone to testify. Okay, with that, I'd like to go ahead and start with House Bill 2630 relating to mental health treatment. This bill authorizes and establishes a regulatory framework for the administration of psilocybin for therapeutic use. First up, we have testimony from the Department of Law Enforcement. Mr. Radula, welcome.
Good afternoon. I'm Jared Radula. I'm the Deputy Director for Law Enforcement with the DLE. To summarize our testimony, we are in opposition, but I want to be clear, we're not in opposition in terms of allowing people or the idea that people are going to be able to benefit from new healthcare, new therapeutic treatment. Our opposition lies in two fundamental areas. The first is that psilocybin and psilocin is still Schedule I federally and within our state. So very similarly, this framework proposed here would create a similar type of framework that exists right now with medical cannabis. And that is, we have this disparity in federal and state scheduling, which makes the discussion unclear for the future. As we know from the medical cannabis experience, there's still problems with it. People are still having issues with banking and having to go to the mainland and do that kind of banking. We can expect similar experiences if we were to create framework like this here. So we think that you know, that kind of headache and sort of things, we're creating a second system now with similar types of concerns and issues. The other point that we make in our testimony is that right now, we feel like the proposal needs a little bit more work to prevent diversion. What is not in the proposal is registration for all participants. Registration is the way in the United States by which all legal controlled substance distribution systems are regulated. With that, it's something as simple as if you get caught by the police, here's my license that I can show that I was in legal possession of this. To things more complicated like terms and conditions of registration, including inventory, mandatory reporting of diversion, keeping daily and monthly records, those kinds of things. So with that, thank you for the opportunity to testify. I have included in our testimony some ways to perhaps improve the proposal and the languages in our testimony. Thank you.
Thank you very much, Mr. Radula, and I appreciate your testimony with all your suggestions. Next, we have testimony from the Office of Wellness and Resilience, the Office of the Governor. Welcome. Please proceed.
Aloha Chair Tarnas and Baladi, Vice Chairs Takayama and Takenouchi, Office of Wellness, Tia Hartsock, Executive Director, Office of Wellness and Resilience in the Office of the Governor. We are in support of HB 2630 relating to mental health treatment. We have seen over the last several years, as the FDA has designated psilocybin as a breakthrough therapies treatment for trauma, some significant data yielding unprecedented efficacy and positive outcomes in clinical treatment of post-traumatic stress, addiction, end-of-life anxiety in terminal patients, eating disorders, and treatment-resistant depression specifically. With all the trauma that our communities experience now and an ongoing basis, looking at alternative treatments and expanding our toolkits to look at trauma treatment is an exciting adventure to go down and look through the research further and see what type of dialogue is needed and warranted for implementation to be effective and efficient. So we look forward to that dialogue, but we are in support of HB 2630. Thank you for the opportunity to testify.
Thank you very much. Next, we have testimony from the Clarity Project. Welcome. Please introduce yourself. The floor is yours.
Ashley Lukens couldn't be here, so she asked me to testify on her behalf. Is that okay, or should I wait for my?
Of course. Please, just introduce yourself, please.
Aloha, my name is Duration. I'm the project manager for the Clarity Project. I'm testifying in support of this measure. We work closely with the Office of Wellness in having a task force since summer of last year. Representative Bellotti was on that task force, as well as medical professionals, other members of government agencies, including the Department of Health. And so we work really closely on supporting this bill, getting a draft together. We're open to amendments to make it stronger, but we just wanted to share, a few key pieces. One is that the FDA has granted psilocybin 2 different times their breakthrough therapy designation, which fast tracks an approval process for medical use federally. And that's specifically because of how strong the research is behind its efficacy in treating severe depression, major depressive disorder, also known as treatment-resistant depression. So these are for patients who are not finding any relief from traditional pharmaceutical methods. And so, if the FDA is able to start to greenlight this therapy, we want to make sure we're following suit as well, especially following in the footsteps of Oregon and Colorado, which have established programs in Oregon for psilocybin and in Colorado for psilocybin as well as other therapeutic substances. We'll be available for questions and just standing in strong support of this bill.
Thank you very much. Next, we have testimony and support from Honolulu Psychotherapy. Kathy Southard. No. Next, we have testimony and support from Christina Braddock, Mana Warrior Collective. Okay, and next testimony and support from Chrysalis Medicine, Christina Rodriguez. Please proceed.
Aloha, yes, hello. Hello, my name is Christina Rodriguez. I'm on Maui in Kihei. Great to see you.
Could you speak into your microphone a little more clearly? We don't hear you much.
I'm a registered nurse. Yes, can you hear me now?
Yes, just hold the microphone close to your mouth, then we can hear you better. Thank you.
Can you hear me now?
Yes.
Hi. So I'm a registered nurse living on Maui in Kihei, and I am in strong support of this bill. In my written testimony, I spoke directly about having healed specifically from sexual trauma. And I would also, and it's purely through the work that I've done with spiritual lineages that have worked with these different medicines, specifically psilocybin and others. And I want to highlight that the medicines, there's a lot of evidence at this point that suggests the medical efficacy of these medicines in healing trauma. And I also want to highlight the spiritual aspects of these medicines in helping to heal trauma. For many different lineages, for thousands of years, these medicines have been used to help people to heal from mental, emotional, and physical, spiritual trauma and issues and concerns. And so given everything that happens in the human experience, these medicines are really incredible opportunities for people to have well-rounded healing. And this comes from somebody who is in the medical field, as well as somebody who understands the efficacy of these medicines from a spiritual perspective. So thank you for the opportunity to testify, and I'm also available for questions.
Thank you very much. Next, we have testimony and support from Nikos Leverins, Drug Policy Forum of Hawaii. Welcome, Mr. Leverins. The floor is yours. Please proceed.
Aloha, Mr. Chair, Madam Chair, Vice Chairs, and members. My name is Nikos Leverins with the Drug Policy Forum of Hawaii. I had the privilege of serving on the Breakthrough Therapies Task Force, hosted by Ms. Hartsock's office and with Ms. Bellotti as a participant. And as my testimony indicates, I think that, when we talk about Schedule 1 and we talk about the therapeutic properties that are increasingly being recognized of psilocybin, we're just getting back to the thousands of years of human history where psilocybin-containing fungi were used as an entheogen. So to the extent that that's been the case, scheduling of psilocybin, particularly on Schedule 1, was a mistake at the outset. So given the fact that, we've had a war on drugs for 50 years plus, we're unworking that a bit. And given the fact that psilocybin and MDMA have been classified as breakthrough therapies by the FDA, we hope that, these substances will soon be rescheduled, maybe to Schedule 3, or in the case of psilocybin, taken off the schedule entirely. So this is a very modest step forward that would provide practitioners and those suffering from major depressive disorder and post-traumatic stress disorder to avail themselves of a therapy that, is life-changing and often very quickly. So mahalo for the opportunity to provide testimony, and mahalo to the Office of Wellness and Resilience for its work in this regard. Thank you.
Mahalo, Mr. Leverins. Next, we have testimony in support from Leanne Nielsen, Aloha Integrative Mental Health. Testimony with comments from Alex Lichten, Hawaii Psychological Association. Testimony in opposition from Elizabeth England, Hawaii Medical Association. Testimony in support from Thomas Cook, Beyond Mental Health. Testimony in support from Amanda Lillibridge. Welcome. Please proceed.
Aloha, chairs and members of the committee. I'm Amanda Lillibridge. I'm here in strong support of HB 2630. I've personally had the opportunity to sit in a safe, guided setting with psilocybin and can attest to the profound transformational healing experience it offers. It helped me relieve of crippling anxiety and depression and unprocessed trauma that I'd sat with since adolescence. And I have yet to encounter a healing modality that has offered me such profound peace. So I just encourage you to move this forward so that we can find better mental health solutions for our communities and for those who need it most. Mahalo for the opportunity to speak.
Thank you for being here. Next, we have testimony and support from Ashley Yamashita. The floor is yours. Please proceed.
Aloha, chairs, vice chairs, and members of the committee. My name is Ashley Yamashita. I live here in Kailua on Oahu. I'm testifying in strong support of HB 2630, and this is my first time testifying, so please excuse me if I'm nervous.
Sure, take a deep breath. We're just regular folks up here. Take your time.
So I'm a certified nurse assistant, mental health technician, and physician's practice assistant working with Queen's University Medical Group over here on Punch Bowl. In my experience working with our community, I see every day the need for alternative mental health treatments and therapies. Also, as someone who struggles with PTSD, treatment-resistant depression, a comorbid anxiety disorder, and OCD, I cannot express the impact a treatment like this would have on my life. I've taken many SSRIs and DRIs, experienced their side effects, and had to discontinue use due to the side effects. In one case, I had an experience with the black box warning that comes with SSRIs. Psilocybin is not only documented in many studies as just as safe or safer than SSRIs, but also has the potential to rewire the brain and create new neural pathways known as neuroplasticity and spines in the brain neural network. The growth of these pathways rewires the brain, creates a way to break free from the diagnoses like major depressive disorder, PTSD, and OCD. Effects of the enhanced neuroplasticity are not only long-lasting, they create new ways of thinking, outlook on life, and sense of self. I know personally how impactful access to this therapeutic modality would be on my life and the lives of many others in our community who are not here today, or could have been today had this treatment been available to them. I ask you to please support this bill, and I thank you for allowing me to testify.
Certainly, and I must assure you, Ms. Yamashita, I would be very nervous if I was in your job, being, working as a certified nurse assistant, mental health technician. I would be just shaking. So I commend you for doing that work. Please just know that your testimony is very meaningful, and I appreciate you taking the time to be here.
Thank you, sir.
Thank you very much. Next, we have testimony and support from Dr. Blaine Williams. Welcome. The floor is yours. Please proceed.
Aloha, Chair, Vice Chair, members of the committee. My name is Blaine Williams. I'm an emergency doctor here in Honolulu. I am testifying in support of House Bill 2630. The emergency department is not what most people think it is. It's actually mostly an ineffective safety net for many of society's problems. And every single day in the emergency department on my shifts, I see patients struggling with depression, anxiety, coming in with panic attacks, various substance abuse problems, alcohol and methamphetamine being big ones, and people suffering from existential distress related to having a terminal illness like cancer. And sorry, I always get a little bit nervous at these.
You too. I would be nervous if I were doing your job. Lordy, I would be nervous. So please take a deep breath. Proceed.
Thank you. Suffice it to say, I see a lot of people who are falling through the cracks, and our current treatments are not working for, I would probably say most people, or at least the people that I see. And every month, there's another study published in peer-reviewed journals showing the efficacy and safety of psilocybin and other medicines classified as psychedelics. But psilocybin, let's just talk about that specifically. That's what this bill is about. Is helpful for treating just what I'm talking about, depression, anxiety, and substance abuse, and especially for patients with terminal illnesses like cancer. And what this bill is asking for is not to just be selling it on the street or have people do this at home, but to have proper medical screening and therapeutic access to work with somebody who's qualified to help them through the sessions and then afterward. I think we need to be progressive because we have too many citizens that are falling through the cracks. Thank you.
Thank you very much, Dr. Williams. Next, we have testimony and support from Dure Shin. Okay, thank you very much. Next testimony and support from Tai Cheng. Next testimony and support from Robert Patterson. Mr. Patterson, please proceed.
Hello, everyone. Can you hear me, everyone?
Yes, we can hear you. Please proceed.
Good afternoon, Board. It's just so wonderful to hear all this positive feedback from people advocating for this medicine. I personally have benefited from this, and I have friends who are veterans and people in the police department who have traveled to Mexico, Costa Rica to try to access these medicines. I also want to thank the police department because I've been part of this process advocating for these medicines here in Hawaii for about 4 years, and it's really wonderful to see their evolution from total rejection to now advocating for support of amendments. And even though they're still advocating against the bill, it's wonderful to see their tone shift and change. And I think that just shows the efficacy of these medicines, the support of the FDA, the support of states like Oregon and Colorado. And I hope that the board takes this into account. And it's just wonderful to see all this advocacy going, all the research suggesting that these medicines can really benefit our community here in Hawaii. So thank you for board for participating in this process. And I think we're confident that the bill can create a task force that can work with all agencies and individuals to create safe access. Thank you very much. I live here in Diamond Head in Oahu, and my name is Robert Patterson.
Thank you very much, Mr. Patterson. Next, we have testimony and support from Jason Guo.
Hi, can you hear me all right?
Yes, I do hear you. Please proceed.
All righty. Aloha, chair members. My name is Jason Guo, and I'm here to testify as an individual firmly in support of this measure. This is not only the first issue I've testified for, but also my first time testifying, so I hope you regard my presence here as proof of my conviction in this bill. I'm from Hawaii, but I currently study neuroscience at Stanford, and I've engaged in psychedelic-related research and coursework both here and abroad in Europe. I don't claim to be an expert in medicine or law by any means, but I am someone who's come face-to-face with many supporters of psychedelic medicine, many former skeptics, and many people who stood to benefit from psychedelic medicine, or at least people who are desperate for an alternative to other drugs. In my written testimony, I zoomed in on a couple of such stories from my time in Denmark, but truthfully, I've been surrounded by mental health issues all my life. Again, I'm from Hawaii. My father's a psychiatrist at Straub. My mother's a clinical psychologist. I volunteer with the suicide hotline, and I've worked as a behavioral health technician with Care Hawaii. And what I've learned from all this is that mental health care, as lovely as it is, leaves much to be desired. I've known people who antidepressants didn't work for, people who stopped because of weight gain or sexual side effects, people who it took weeks or months for the effects to kick in. We compare that to psilocybin, whose benefits we all know are rapid acting, very efficacious. I don't need to speak further on that. And here, I just propose that we have a chance to just change these shortcomings and opportunity to, that even the most extreme skeptic would have to say is somewhat promising. And I just beg you, chair members, that you seize that opportunity today. Mahalo.
Thank you very much for your testimony. For those who are listening, in his testimony, Mr. Guo says, I aspire to attend medical school and pursue psychiatry in Hawaii. I urge you to do just what you aspire to do. We could use you back here in Hawaii, so please go on to medical school and pursue psychiatry and return home.
Thank you, I appreciate that.
Okay, let's move on. Testimony and support from Melissa Sanchez. Please proceed.
Aloha.
Yes.
Aloha. My name is Melissa Sanchez, and I currently reside in Oregon. I've worked closely with the state of Oregon as well as my local government to implement the psilocybin access model that we have here. The program has basically been operational for 1 year, and within this 1 year, we have seen over 800 individuals gain access to psilocybin in a regulated setting. Of those 800 stories, I've heard several personal success stories from individuals who had been long suffering with mental health challenges. And after even one dose of psilocybin containing mushrooms, they had transformational results. Many states, Dorian mentioned earlier, Colorado is following similar footprint of Oregon. And I believe that Hawaii should definitely follow suit. I'm testifying in support of this bill because I believe that individuals should have access to natural alternatives that have proven results. And I think that in our country, we are fighting a big stigma established in the 60s and 70s against psilocybin and other psychedelics that science has long proven should no longer be the case because of their marvelous results. I'm available for any questions as well right now or after about the program in Oregon. Thank you.
Thank you very much. Next, we have testimony and support from Josh Poroko, MD. And next, testimony and support from Nicole Bell. And we have, in addition, 20 testifiers in support that sent in written testimony and 1 testifier in opposition that sent in written testimony. Is there anyone else here or on Zoom that wishes to testify on this measure, HB 2630? If not, questions, members? Let me first start with the Judiciary Committee. Any questions, members? No? Let me offer to you, Chair.
Questions, members? Go ahead, Representative Kobayashi.
Does Department of Health have a position?
Please introduce yourself and proceed.
Good afternoon, Lauren Kim, Policy and Planning Officer for the Department of Health. Rep. Kobayashi, the department is not taking a position on this measure. We were part of the discussion in the interim to produce a bill that would stand a chance, and so we've had our opportunity for input. But as we are not named, we are erring on the side of wisdom and caution and not taking a position. Thank you.
Any other questions from the members? None.
Seeing none, let's move on to the next measure. Thanks very much. What we're going to do, folks, just so you know, we're going to be hearing the measures for which there is a joint referral of the two committees, and then we'll vote on those measures. Then we'll move on to the rest of our hearing agenda for Judiciary and Hawaiian Affairs. Next up, we have House Bill 1566 relating to consumer health data. This bill establishes requirements, including additional disclosures and consumer consent regarding the collection, sharing, and use of consumer health data information, establishes rights for consumers regarding their health data, including the right to have health data deleted. It prohibits the sale of consumer health data without a consumer's signed, valid authorization, and prohibits the erection of a geofence around healthcare centers. On this measure, first up, we have testimony with comments from the Department of Commerce and Consumer Affairs. Mana Moriarty.
Good afternoon. Mana Moriarty, Executive Director of the Office of Consumer Protection, Department of Commerce and Consumer Affairs. Excuse me, I have a little bit of a cold. This bill appears to be incredibly well-intentioned. We have significant concerns about just exactly how this could be effectively enforced. And we think if this bill were to proceed, we would need to have some serious discussion about the technological capacity of the state to actually enforce the law as written. I'll leave it at there. I'm happy to engage further with the committees.
Thank you very much. Hope you feel better soon. Next, we have testimony and support from Jack Lewin of the State Health Planning and Development Agency. Next, we have testimony in support from Kelly McCanless, International Association of Privacy Professionals. Please proceed.
Good afternoon, chairs, vice chairs, and members of the committee. My name is Kelly McCandless, and I'm testifying as an individual. I'm retired now, but previous to this, I was the compliance officer and privacy officer for one of Hawaii's largest employers. I am in support of this bill, and I'd like to tell you why. One of the reasons is it's got some very particular points that I think are important that may sometimes get glossed over from people reading the bill, and that is, first off, Section 10. There is a section in there, a bullet, that specifically exempts groups that are subject to HIPAA. So anybody that's concerned that, oh, it's going to stop medical research is being done by hospitals, by doctors, by groups that are subject to HIPAA. It's not being done by Fitbit. It's not being done by other apps. It's not being done by WebMD.com. But those companies are siphoning off large amounts of medical information. There are no restrictions to them. They're selling them to whoever they can in some instances. And there are some horror stories out there that are anecdotal, but it's what we've got on what's happening when medical information is being sold from apps and from websites. And that's the targets of this bill. It's not the companies that are subject to HIPAA, and that's why they're very explicitly exempted in Section 10. So if you've got questions on HIPAA, if you've got questions on that, because I was a HIPAA compliance officer and I was privacy officer for one of the largest companies in Hawaii, I'd be happy to answer any questions you've got, and I do stand in support of this bill. Thank you very much.
Thank you very much for testimony. Next, we have testimony and support from Jen Wilbur, Planned Parenthood Alliance Advocates. Welcome. The floor is yours. Please proceed.
Thanks again. I'm Jen Wilbur, State Director for Planned Parenthood Alliance Advocates. We're in strong support of this measure. Patients are increasingly more afraid to seek care because of privacy concerns and are asking questions such as, should I delete my period tracker app, or is it safe to Google where to find a vasectomy or an abortion provider? In 2022, in May of 2022, SafeGraph, a location data broker, sold aggregated location data of people who visited abortion clinics, including more than 600 Planned Parenthood clinics across the country over a week's period for $160. The data showed where patients had traveled from, how much time they spent in the health facility, and then where they went afterwards. Those who obtain healthcare should not be subjected to targeted ads about their private healthcare decisions, and people should not have their locations tracked and shared via geo-targeting when seeking healthcare. Patients' data should not be left vulnerable to be shared by anti-choice groups used in prosecutions or employed for targeted advertising. Thank you for your support of HB 1566.
Thank you very much. I appreciate your testimony. Next, we have testimony with comments from Kaiser Permanente. Welcome. Please proceed.
Chair Tarnas, Chair Bellotti, Jonathan Ching testifying on behalf of Kaiser Permanente. I apologize, we did submit late testimony, so.
We received it and we've circulated
Thank
that.
you for the consideration. So we are in full support of the intent of this bill. However, as drafted, and I do recognize that there is an exemption for entities that are covered under HIPAA under Section 10, but we do believe that Section 8, we would like to have explicit exemption for covered entities, and I'll explain why. One of the great things that we provide for our members is when they come to our facilities, they're able to check in virtually. We are able to help direct them to where they're going, and that essentially is what geofencing would be prohibited under this bill. So understanding, we are a covered entity that is not selling that data, but we believe that as drafted, that section in Section 8 is a little bit overbroad, so we would like that explicit exemption for those covered entities that are subject to HIPAA. I'm available for any questions, but again, supporting the intent of the bill and just asking for an amendment. Thank you, chairs.
Thank you very much. Next, we have testimony and support from Michael Goliup, Stonewall Caucus, Democratic Party, Hawaii. Next, we have testimony and support from Matt Schwartz, Policy Analyst with Consumer Reports. Please proceed.
Thank you, chairs, vice chairs, and members of the committee. Thank you for allowing me to testify today. My name is Matt Schwartz. I'm a policy analyst with Consumer Reports based in Washington, D.C. Consumer Reports has been a consistent advocate for strong consumer privacy protections around the states, and we're happy to support HB 1566. As the universe of entities that have access to our sensitive health information grows by the year, it should come as no surprise that many of these companies are failing to safeguard it with the appropriate care. Consumer Reports has previously reported on examples of mental health apps and period tracking apps selling information about their users to large social media platforms for marketing. And the FTC has recently settled cases with an online pharmacy and reproductive health app for sharing information with social media platforms as well. When this type of information is used for those unexpected purposes by the business, or even worse, made public, the list of possible harms is immense. It can cause social embarrassment or stigmatize the individual. It can be used against them in an employment context, or be used to increase their insurance premiums. Perhaps worst of all, it could actively endanger the individual and dissuade them from receiving care. HB 1566 would remediate many of these harms by creating new and much needed protections for consumers' sensitive health information. Crucially, this bill provides for a private right of action, which is absolutely key to ensuring that companies actually comply with their new obligations under this act. Under an AG-only enforcement framework, businesses that recognize that the AG is only capable of bringing a handful of enforcement actions each year might simply ignore the law and take their chances in evading detection. And we just think it's appropriate that consumers should have the ability to hold companies accountable. So thanks so much for allowing me to testify again today. I'm happy to answer any questions that you may have.
Thank you. If you have not already sent in written testimony, please send it in. That'd be great.
Okay, I think I submitted it, but I will check.
Did it come in? Okay, yeah, we do have it. Sorry, we do have it. I apologize. We do have it.
Thank you.
Thank you. Okay, next we have testimony in opposition from Tina Yamaki, Retail Merchants of Hawaii. Please proceed.
Aloha, chairs. I'm Tina Yamaki with the Retail Merchants of Hawaii. And while we understand the intent to ensure that consumers have important protections on the use of their data and that they have to continue to be able to access health care, including reproductive health care or gender affirming care. However, as it is currently written, we're respectfully opposing it as this measure because we do have some concerns. As drafted, the overly broad definitions would negatively alter the consumer experience and fail to accomplish what this legislative intent of the bill is. Key definitions in the law are exceptionally vague. For example, the definition of physical or mental health status includes basically anything that involves having a human body, and the data is not limited to that of the companies actually using to diagnose or treat actual conditions. We also have a few other examples in our written testimony as well, and it's very lengthy, so I'm just going to stand on our written testimony. Mahalo.
Thank you very much. Next, we have written testimony from numerous individuals, 2 with comments, 17 in support, and 3 in opposition. Is there anyone else here in the room or on Zoom that would like to testify on this measure, HB 1566? If not, questions, members. First, the judiciary. Any questions? Seeing none, over to your committee.
Any questions, health members? Seeing none?
Okay, let's move on to the next. House Bill 1571 relating to first responders. This requires the state to share in the cost of county first responder personnel fulfilling state-imposed new mandates or increases in the level of service under existing programs. On this measure, we have testimony from Ken Fink, Department of Health, or his representative.
Good afternoon, members of the committees. Lauren Kim, Planning and Policy Officer for the Department of Health. The department respectfully opposes this measure. It is unnecessary. The first responders that we oversee, namely emergency medical technicians and paramedics, are subsidized or they're financed fully by the state. We respectfully request this measure be deferred unless the department can be exempted and Chapter 321 and amendments away from Chapter 321 are recommended. We believe that if the intent of this law, or one of the intents of this law, is to assure financial parity and cost sharing for other first responders, such as law enforcement or firefighters, then that's not the purview of the Department of Health. And again, we request that there be no amendments made to Chapter 321, nor reference to DOH. Thank you, and I'm available for questions.
Thank you very much. Next, we have testimony and support from Tamara Paulton. Is there anyone else here or online wishing to testify on House Bill 1571? Yes, Mr. Walker. Please introduce yourself and please proceed.
Aloha mai kako chairs, vice chairs, and members of the committee. My name is Michael Walker. I'm the statewide fire protection forester for the Department of Land and Natural Resources, Division of Forestry and Wildlife, Ekalamai, but I was monitoring this bill and wanted to just come in and testify that the department does support this bill, particularly when it comes to the fire service in the counties. If there's any new measures that the state mandates upon them, that they be supported in that. So I'm available for questions if you have.
Thank you. Anyone else wishing to testify in this measure? If not, questions, members? We'll go to judiciary first. Over to your committee.
Questions for the Health Committee? Representative Kobayashi.
Department of Health, we've had several bills talking about requiring training of first responders in various things, everything from dementia to Alzheimer's. If we pass such a law, would this then trigger a state cost sharing?
Possibly if the mandated training is not specific to emergency medical services. Again, everything my department does, the Department of Health does for emergency medical services, which are either contracted out to the private sector or handled by the counties, is paid for by the state, whether an upfront appropriation or a reimbursement, for example, trainings. I cannot speak to firefighters or law enforcement. I would assume that that's the intent of this bill, is to make sure that the state has a cost share when, and I think the constitutional article being referred to is the unfunded mandate. And so I believe this would be appropriate. This, I wouldn't say it's appropriate. It would apply to law enforcement and firefighters, but not to first responders within the Department of Health, such as EMTs and paramedics.
Thank you.
Any other questions? Seeing none?
Okay, no other questions. Thank you very much, members. You know, as I mentioned, these were the measures that had a referral to both committees. So I'd like to go ahead and go into decision-making on these bills now, and then we'll move on to the other bills on our Judiciary and Hawaiian Affairs agenda. Up to the top of the agenda, excuse me, House Bill 2630. I think that this is very appropriate for us to move forward after recognizing that that psilocybin has been recognized as a breakthrough therapeutic medicine that would provide substantial public benefit, and that the FDA is fast-tracking their process. So I think that we can move forward with confidence that this is a good thing for the community. And what I would like to do, however, though, this is still in process. It's got 2 other committees it has to go to before it even crosses out over to the Senate. So I want to amend the bill to produce a House Draft 1. We're going to defect the effective date to the year 3000. That's just to ensure that this bill will have more time and more attention to get the details right. I want to make some technical amendments. In particular, I want to make sure that we've properly defined licensed mental health professional, and so we'll correct that. I acknowledge the Department of Law Enforcement's recommendation to set up a much more institutional framework for regulating this. I think that's premature at this time. I would like to move forward and really rely on the practitioners for those, so that they can actually guide the implementation of this going forward. So my recommendation is to include in the committee report that the next committees should consider what type of registration of providers there might have, or inventory of the psilocybin itself. I'll leave that to the Consumer Protection and Commerce Committee, which is the next one. So my recommendation is to pass with those amendments. Let me first go to my committee. Any questions or concerns? If not, you want to ask if there's any questions or concerns?
Any questions or concerns? Health Committee? Seeing none?
Okay,
So your improved definition for licensed mental health professionals will include explaining what the word therapist means.
Yes.
Thank you.
Any other questions? If not, Vice Chair for the vote.
Voting on House Bill 2630, passing with amendments. Chair and Vice Chair vote aye. Representative Evslin? Aye. Representative Ganadin? Aye. Representative Holt? Aye. Representative Ichiyama? Aye. Representative Iligan? Aye. Representative Kong? Aye. Representative Miyake? Aye. And Representative Souza? Aye. Chair, your recommendation is adopted.
Vice Chair for the Health Committee for the vote.
Health Committee voting on HB 2630. Chair's recommendation is passed with amendments. Chair and Vice Chair vote aye. Representative Amato? Aye. Representative Iligan? Aye. Representative Kobayashi?
No.
Representative Martin? Aye. Representative Nishimoto? Aye. Representative Garcia? Chair, recommendation is adopted.
Thank you very much. Next, moving on to House Bill 1566. I think this is an important measure to protect consumers, and that they should have the ability to decide what of their health data is used. So I would like to move this bill forward with amendments, House Draft 1. Because this is the only committee it's going to be in the House, I want to defect the effective date to 3000 so that we can have another look at it after the Senate looks at it. I want to make some technical amendments. I would like to adopt the recommended amendments from the Hawaii Insurers Council the State Health Planning and Development Agency, and Kaiser Permanente. And I would also like to include in the committee report that the Department of Commerce and Consumer Affairs does have concerns about enforcement, and that we should hear more from DCCA and see whether or not we need to do something to address those. But I'm not going to include anything in here. This bill does not have any appropriations in it, and I'm not proposing to put any in at this time. So that's my recommendation, to move it out with amendments. Any questions from the Judiciary and Hawaiian Affairs Committee? Seeing none, any questions from your committee?
Any questions?
If
Seeing
not,
none?
Vice Chair for the vote.
Voting on House Bill 1566 with amendments, all members being present, anyone voting no or with reservations? Seeing none, your recommendation is adopted.
Thank you.
Health Committee, same recommendation. Vice Chair for the vote.
Voting on HB 1566, Chair's recommendation is passed with amendments, noting all members present. Any reservations or noes? No vote for Rep. Garcia. All others vote aye. Chair recommendation is adopted.
Thank you. On the final measure of this joint committee, it's House Bill 1571, relating to first responders. I'm going to take the recommendation from the Department of Health and defer this measure. I would like to check in with Mr. Walker afterward to see if there's something we can do to address your particular issues. But I think in terms of emergency responders, I'm going to take the DOH's recommendation and go ahead and defer. So we can keep working on the issue in another bill at another time. Okay, that's it. Thanks so much for the joint committee. We're going to take a brief recess so we can allow the Health Committee to depart. Reconvening the hearing of the House Committee on Judiciary and Hawaiian Affairs. We just said aloha to the Committee on Health and Homelessness. We are here in a joint committee hearing. Now we're moving on to the rest of our agenda, which is just Judiciary and Hawaiian Affairs. First up, House Bill 1596, relating to controlled substances. This exempts drug paraphernalia for marijuana from certain penalties under the Uniform Controlled Substances Act, makes the possession of less than 1 ounce of recreational marijuana a non-jailable violation, punishable by a fine of $25. First up, we have testimony in opposition from the Attorney General.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Corey Young. I'm a Deputy Attorney General from the Criminal Justice Division. On behalf of the department, we'd like to thank you for this opportunity to testify. We are opposed to this bill for a number of reasons. The first being its reduction of the age at which people can be prosecuted for a Class B felony for distribution of drug paraphernalia to minors. As at present, the law actually does a very good job of recognizing that social groupings often encompass people of different ages. So right now, if an 18-year-old were to share drug paraphernalia with a 15-year-old within their social group, as long as that 15-year-old is within 3 years of age of the 18-year-old, that's still a violation. What we're afraid of is 18, 19, and 20-year-olds being able to freely distribute drug paraphernalia to much younger children, 12-year-olds, 10-year-olds, and basically proliferate the use of this drug paraphernalia by a much more vulnerable group of users. We are also basically recommending that as to the drug paraphernalia changes to subsection F, if the committee would again consider adding an age requirement to that. Right now, the bill would basically make drug paraphernalia as it pertains to marijuana paraphernalia exempt from any type of prosecution. We would recommend leaving it as a violation for people under 21. Our understanding of most of the legalization bills are looking at legalizing for individuals of 21 and over. So basically making drug paraphernalia accessible to that group, that age group, doesn't make a lot of sense. Also, we would point out that the studies have indicated that marijuana does have a tendency to affect brain development adversely, especially in young people. So keeping particularly people of a younger age, 20 and younger, from getting this type of drug paraphernalia would be beneficial. Finally, as to the proposed change to 712-1249, the promoting detrimental drug charge, we would ask that the current level of 3 grams be left intact. Basically, raising it to under an ounce would multiply the amount of marijuana that someone could have on their person by 9 times, while cutting the proposed fine from $130 to $25. Our concern is that this is going to increase not just use or make the use of marijuana more accessible. It's going to make the illegal sale of marijuana more accessible. Essentially, when you're looking at under an ounce, you're looking at 28 grams, so well over the 3-gram limit that's currently set. That's dealer amounts for us. That's street dealer amounts. That's not huge quantities, but that's an amount that someone can be on the street selling and still being insulated from basically being caught in possession if they are stopped by law enforcement. So someone selling amounts of standard amounts of like 5 grams or 10 grams could have 2 or 3 sales worth of marijuana on their person and still be under the limit if it were to be increased to just under an ounce. We're also concerned about the fact that if you're looking at decriminalizing to that high a degree, it's bordering on legalization, which without the benefits of actual legalization. What you're looking at is potential increased usage, but without the ability of the government to regulate the marijuana that's going out to the consumers, without the ability to test it, without the ability to make sure that it's free of additives, pesticides, or other toxins. That's a huge concern for us. Also, the community as a whole does not get the benefit.
Summarize, that'd be great.
Yes, sir. I thank you for the opportunity to testify, and
Sure.
I'll be present for any questions.
Thank you very much for your testimony. Next, we have testimony in support from the Office of the Public Defender.
Good afternoon, Ben Lowenthal from the Public Defender's Office. The Public Defender's Office is in support of this bill because it further brings us closer in line with the realities of the situation when it comes to cannabis use, not only here, but in all the other states that have recognized that this is a substance that needs to be treated differently than other substances described in the Controlled Substances Act. I am available for questions.
Thank you very much. Next, we have testimony from the Community Alliance on Prisons. Ms. Kat Brady, please proceed.
Aloha, Chair Tornes, Vice Chair Takayama, and members of the committee. Kat Brady testifying in strong support for Community Alliance on Prisons. You know, the first discussion made me feel like I was in 1920. Prohibition seems to be raising its ugly head. And we know that a lot of the problems with prohibition stemmed from racism. And it was about immigrants who had bars and, oh, geez, this is really bad. And, we need to look at the past and say, was that something that actually helped our community, or did it divide our community? And when you look at the people who get arrested, you see that it's the same story. It's about racism. And one of the downsides of prohibition was the impact on health of the nation. And once something is prohibited, people seek other ways, and people were drinking things that were not good for them. So I want to leave you with a quote from George Santayana, who said, "Those who cannot remember the past are condemned to repeat it." Please don't condemn us to repeat this mess.
Thank you, Ms. Brady. Next, we have testimony and support from Carrie Ann Shirota, ACLU of Hawaii. Please proceed.
Aloha, Chair Tarnas, Vice Chair Takayama, committee members, Carrie Ann Shirota on behalf of the ACLU of Hawaii. We strongly support this measure. As you're aware, arrest for possession of small amounts of cannabis or related paraphernalia has been historically one of the most common points of entry into our criminal legal system. In 2019, the legislature rightfully passed and the governor signed Act 275, which decriminalized possession of 3 grams or less and imposed a fine of $130. The current tiny threshold, while improvement to past cannabis prohibition policies, continues to result in hundreds of individuals being arrested in Hawaii each year and facing possible jail time for simple possession of cannabis in our severely overcrowded jails with inhumane conditions of confinement. We ask that you pass this measure and that we also think about who is most harmed by the war on cannabis. It's been primarily men under the age of 25, people from under-resourced communities, and most specifically, Native Hawaiians in their own homeland. Please pass this measure. Thank you.
Thank you very much. Next, we have testimony and support from Karen O'Keefe, Marijuana Policy Project. Please proceed.
Hello, apologies that I'm on my phone. I'm Karen O'Keefe. I direct the State Legislative Department at the Marijuana Policy Project, and we strongly support this bill. This would bring Hawaii's decriminalization law closer in line with all of the other states. 31 states have either legalized or have decriminalized cannabis, and all of them are higher than Hawaii's. The vast majority of them apply to an ounce or more. So this would bring it closer in line. The 3 grams threshold is smaller than most people purchase. Usually people purchase at least an eighth of an ounce, which is 3.5 grams. This is the reason that, as Carrie Ann mentioned, we're still seeing hundreds of people marred with criminal records for possessing a small personal use amount of cannabis, and those criminal records can continue to haunt people for life. It's currently a petty misdemeanor, which is punishable by up to 30 days in jail to possess between 3.3 grams and 1 ounce. This would also reduce the fine. Right now, the fine is $130, which is higher than a lot of the other states have. According to a survey from the Fed in 2022, 18% of Americans are unable to pay $100. They don't have enough savings to do so. In addition, the current paraphernalia penalty is up to $500. So there's a significant amount of people who simply could not afford to pay these hefty fines, which double up onto each other. So by exempting cannabis paraphernalia simply for use and for storing cannabis, things like baggies, you avoid having this double penalty for essentially the same conduct. So we appreciate consideration of this bill, and I thank you for the opportunity to testify.
Thank you very much. Next, we have testimony and support from Frank Stiefel, Last Prisoner Project. Please proceed.
Yes. Good afternoon, Chair, Vice Chair, and members of the committee. My name is Frank Stiefel. I'm testifying on behalf of the Last Prisoner Project, which is a nonpartisan nonprofit focused on cannabis-related criminal justice reform. The Last Prisoner Project supports HB 1596. The war on drugs and the criminalization of cannabis have created a racially inequitable criminal legal system that has disproportionately impacted people of color, including Native Hawaiians. We at the Last Prisoner Project believe that no one should suffer the collateral consequences of cannabis criminalization. HB 1596 will further reduce the criminal penalties for cannabis possession, which is why we support the bill. We look forward to continuing to support Hawaii in its pursuit to end the war on drugs by beginning to dismantle the racial injustices that the criminal legal system has perpetuated during prohibition. Thank you for your time.
Thank you, Mr. Stiefel. Next, we have testimony and support from Nikos Leverins, Drug Policy Forum of Hawaii. Please proceed, sir.
Aloha, Mr. Chair, Vice Chair, members. Nikos Leverins with the Drug Policy Forum of Hawaii. In strong support of this bill. Ideally, possession of 1 ounce or less would not be a citable offense at all, given the ramifications of cannabis on public order and on health. One hopes that those members of the criminal legal lobby, including our elected county prosecutors and mayors, who are eagerly brandishing their opposition to commercial marijuana for public attention, will recognize the importance on focusing on other salient matters related to the misuse of alcohol and other drugs, including the ongoing need for access to community-based, non-carceral behavioral health treatment and permanent supportive housing units that can facilitate the continual delivery of medical care and social services. While exempting cannabis paraphernalia is a worthy goal in its own right, I believe that Hawaii should join those states that have no penalty, civil or criminal, for drug paraphernalia as outlined in HB 431. Drug paraphernalia laws are of relatively recent vintage. They are a Reagan-era relic that should be consigned to the dustbin of history. Alaska has never had a drug paraphernalia statute, very red state, Alaska, and just last year, Minnesota rescinded its drug paraphernalia statute. Why did they do so? Even though we've decriminalized drug paraphernalia here in Hawaii, it is still used as a pretext to arrest and potential incarceration. Even untraceable amounts of residue and traces of controlled substances like heroin will result in a 5-year prison term and a $10,000 fine. So I think if the objective is to continue to criminalize communities of color, including our Native Hawaiian, Pacifica, and Black communities on this island in perpetuity, as drug law enforcement has done at great cost to their families, their communities, and our state coffers, then fine, leave it as is. If not, let's take corrective measures and recalibrate our policies. Mahalo.
Thank you very much. And we have written testimony in support from 12 individuals and 1 testimony in opposition. Is there anyone else here or online wishing to testify on this bill, House Bill 1596? If not, questions, members? Seeing none, we'll move on. Thank you very much for the testifiers. House Bill 1595, relating to expungement. This creates a state-initiated process to expunge records of arrests and convictions pursuant to Section 712-1249, Hawaii Revised Statutes, at no cost to the record holder. Requires the Hawaii Criminal Justice Data Center to submit biannual reports to the legislature until all eligible records are expunged. On this measure, we have testimony first from the Attorney General. Welcome. Please proceed.
Good afternoon. My name is Michelle Pu'u. I'm a Deputy Attorney General with the Criminal Justice Division of the Department. We are essentially the statewide prosecutors. We are testifying in strong opposition to this bill. Currently, this statute 712-1249, promoting a detrimental drug in the 3rd degree, is still in the penal code. So to propose that it would be part of an automatic expungement mechanism would actually create a revolving door, essentially, allowing for simply arrest, conviction, and subsequent expungement, and that cycle would still be ongoing so long as it remains within the penal code, which would not be productive use of anyone's time. Additionally, we are of the position that maintaining the current process, which requires a simple application by anyone who is desiring expungement, continue, as that would assist with identification of those that are requiring expungement, requesting expungement, and it would also ensure proper dissemination of sensitive documents, that they are going to the right address, to the right recipient, and also provide necessary sensitive information that is getting to the right source, because we would have current information for that individual via the application that they provide. That process has been simplified over time. It has been reduced to a 1-page application where very minimal information is required to be provided to facilitate that process. The application fee is also pretty minimal. I believe it's $35. upwards to $50, depending on what it is you're requesting. And also, not sure if the intent of the overall bill is inconsistent with the outcome as it's currently written. I'm not sure if it was intended to apply to just the 3 grams or less, as is noted in the 712-1249. It seemed that was the intent, but that's not clear based on how it's written. 3 grams or less is current for the violation amount per 712-1249, but the way it's written is for 712-1249 all offenses, which would include any amount of marijuana and would also include any Schedule 5 substance, which falls outside the purview of marijuana, which was unclear whether or not that was the intention of the bill. So that's another one of our concerns. So we're testifying in opposition to this, and we appreciate the opportunity to provide you with our testimony this afternoon. I'll
Thank
stay
you.
for questions, should there be any.
Yes, please, stick around, that'd be great. Next, we have testimony in opposition from the Department of Corrections and Rehabilitation. Next, we have testimony in support from the Office of Public Defender.
Good afternoon. You know, before I was in my current position here, I was at the Maui office for close to 6 years, and I can tell you that in the waiting room for every public defender's office in this state, and even in the courthouse, in our little mini offices, we have a stack of applications. We are not authorized as public defenders to represent our former clients when they try to find and track down the documents that are required to be attached, when they have to keep track of the deadlines and the periods in which they become eligible for expungements. And we're certainly not in a position to assist our indigent clients in paying fees of $30 to $50. And so we do believe that this bill and the other bill on this agenda is a step forward because the records are kept by the state, and the state is in the best position to identify when a person is eligible for expungement and should take the initiative. So we do hope that this bill and the next pass, that we join the other states that have started moving towards state-initiated expungement processes. Thank you.
Thank you very much. Next, we have testimony, the comments from the judiciary.
Good afternoon, Chair Tarnas, Vice Chair, members of the committee. On behalf of the judiciary, Thomas Berger, staff attorney for the Hawaii Supreme Court. To briefly summarize the judiciary's written testimony, the judiciary requests this bill be deferred to allow time for further study. First, the judiciary cannot support those provisions of the bill which would limit judicial review and discretion. Second, the bill would cause significant operational impacts to the judiciary and significant cost. Third, clarification is needed on whether this bill is intended to cover just marijuana or to also cover other substances. To conclude, as drafted, the judiciary is not able to support House Bill 1595. However, the judiciary shares the committee's concerns about simplifying the process for self-represented parties. And I'd like to thank the bill's introducers for allowing this discussion to take place. I'm available to answer any questions, and thank you for the opportunity to testify.
Thank you very much. Next, we have testimony and support from the ACLU of Hawaii. Welcome. Please proceed.
Aloha Chair, Vice Chair, Committee members, Carrie Ann Shirota, Policy Director of the ACLU Hawaii. We thank you for scheduling this bill for hearing. We strongly support. We want to highlight some of the data to think about how this actually impacts people. According to a recent report by the Attorney General's Office, there are currently over 50,000 arrests and 10,000 convictions currently in the system for low-level cannabis-related offenses. For every individual, think about their family. And I think I want to highlight a story. There's a professor who teaches a cannabis law class at William S. Richardson, and he, in traveling the islands, met with somebody on the island of Kauai who is a teacher by training, has a credential. We know that there's shortages of teachers, counselors in our school. This person could not get a job because of a past cannabis conviction. And so we really need to see this in the appropriate context. By implementing expungement provisions for cannabis and more broadly the other measure we'll get to, this is an incentive in enhancing and increasing our pool, our workforce. We know that so many employers can't find workers. I want to point out that Prison Policy Initiative, a national think tank, National Resource Reentry Center, said that a criminal record reduces a job seeker's chance of getting a callback or job offer by nearly 50%. In stark contrast, expungement helps people move on with their lives and get back to work. Research from the University of Michigan finds that people are 11% more likely to be employed and are earning 22% higher wages 1 year after a record has been cleared. And on a practical level, I formerly worked as a public defender, worked for a reentry program on the island of Maui. It is not so simple as filling out this expungement process. Typically, if you have money, you can hire an attorney to help you navigate the court and Hawaii Criminal Justice Data Center process. For someone, that $30 or $50 with other records is taking away food from the table from their children. And so we ask that you look at what's been done in numerous other states that have been expunging records for cannabis offense for using a plant, a known medicine for thousands of years, and that we undo the harm, and again, keeping in mind who is most impacted, Native Hawaiians, Pacific Islanders, and Hawaii. Please pass this measure.
Thank you very much, Mr. Rota. Next, we have Frank Stiefel, Last Prisoner Project in support. Please proceed.
Yes, hello again, Chair, Vice Chair, members of the committee. My name is Frank Stiefel, and I'm testifying on behalf of the Last Prisoner Project to show our support for HB 1595, which is a narrow expungement bill that is solely focused on providing record clearance relief for individuals who have a criminal record for cannabis possession. The legislature took a major step forward in 2019 by decriminalizing cannabis possession. HB 1595 closes the loop on the decriminalization legislation that was passed in 2019 by ensuring that individuals no longer suffer any of the collateral consequences associated with having a criminal record for cannabis possession. Individuals who have these cannabis possession records are already eligible for expungement. However, as national research shows, less than 7% of people who are already eligible for record clearance relief ever have their criminal records expunged because of the cumbersome nature of the record clearance process. Many states have begun to address the complicated process of having to petition to have a cannabis record expunged. Since 2018, 13 states have passed legislation to create state-initiated record clearance processes for cannabis records. HB 1595 would simply automate record clearance for individuals with a cannabis possession record by having the Attorney General's office initiate the expungement process. This state-initiated expungement process would promote public safety by expanding access to employment, housing, and educational resources that allow for community reintegration and stability. HB 1595 ensures that individuals who continue to suffer the consequences of a penalty the state has already decriminalized are applied evenly, so no one is left behind. I thank you for your time, and I'll be here to answer any questions. Thank you again.
Thanks very much. Next, we have testimony and support from Karen O'Keefe, Marijuana Policy Project. Please proceed.
And now I'm unmuted. Good afternoon again. We enthusiastically support this bill, which would have state-initiated expungement for simple possession of marijuana and a few other substances that are classified alongside of it. About half of all Americans admit to having used cannabis. Who is branded with a criminal record that derails their lives with economic hardship is arbitrary in some cases and more often is based on racial discrimination. It is vital to wipe out those economic life sentences that make it very difficult to get a job or housing. One survey found 92% for state-initiated expungement. That alone shows that the petition-based expungement is not wipe out these records that are so devastating to people's future. I do urge 2 amendments to make the bill even stronger. First, I think the bill should include that landlords and employers cannot discriminate against a person for having a past conviction for cannabis possession. This will cover the fact that there are some people living in Hawaii who got their convictions in states that won't have expunged those convictions. Also, it will cover it in case there are criminal databases that include convictions, or if a person checks the box and does not know they aren't required to do so. Second, we urge that you include a provision so that all criminal records databases have to wipe out all expunged convictions. Other states, such as Indiana and Virginia, have done this, Of course, most people who are checking records don't look at the Hawaii judiciary site. They find it through these services that are operated by third parties. So to make sure this truly prevents these records from haunting people for possessing a substance that most Americans think should be legal, it should also mandate that those be wiped out of those databases. Thank you so much for bringing this forward and for your time and consideration.
Thank you very much. Next, we have testimony and support from Jennifer Brown, Hawaii Innocence Project. Please proceed.
Aloha. Thank you to the committee, Chair Tarnas, Vice Chair Takayama, for allowing me the opportunity to testify today. My name is Jennifer Brown. I'm a clinical faculty member at the William S. Richardson School of Law, where I serve as a teaching instructor, associate director, and supervising attorney for 2 of our legal clinics that provide advocacy and pro bono legal representation for individuals who are currently or have been formerly incarcerated through post-conviction proceedings, which includes expungements and other forms of clemency. In the Hawaii Innocence Project, we represent individuals who've been wrongfully convicted, and in the Beyond Guilt Clinic, we represent individuals who've been unjustly or overly sentenced due to our state's punitive criminal legal system. I'm testifying today in strong support of this bill, which would allow those that have been convicted of certain drug offenses to have their records cleared or expunged, assuming that they meet criteria. As my colleagues at the ACLU and PP and LPP and others have testified to, the impact of cannabis convictions has long and lasting implications. And in a state that has so much community support for legalization of the adult use of cannabis, no one should have to suffer the financial, social, employment ramifications of having a cannabis conviction on their records. The importance of this bill is to provide an automated process to have their records expunged. After hearing and reading the testimony and the concerns raised by the AG and judiciary, that the proposed process would be unduly burdensome on their agencies, and that the process for expungement is already a simple process, requiring just a one-page application submitted by the person that's wanting to get the records expunged. I would like to submit testimony in opposition to these statements, as the process is not as simple as they mentioned. A few years ago, with many of the members who have already testified in support of this bill here today, we held the first pilot expungement clinic event at the clinical building at the law school. Through this event, we discovered that it's not only the public, those with convictions or non-convictions, who are not aware of the process to get an expungement, that they were actually the attorneys as well that volunteered with us that were not sure what the process was for an expungement, who qualifies, and how do you seal court records. Many of the individuals that we helped through that event that day were told by others, including attorneys, that they may not be eligible for an expungement, or that the attorney would have to charge them sometimes hundreds or thousands of dollars for an expungement. This shows the current process as it stands is not simple or easy. It's not even easy for attorneys to understand. This was evident by the fact that when we held this event, the attorneys who so graciously donated their time to meet with clients and help them with their expungement process also had to be trained on what the expungement process was, what qualifies. Which also basically we kind of altered our clinic, pilot clinic, to just focus on non-convictions, as that was more understandable for the volunteer attorneys that were helping us. Through that event, we were able to help over 40 individuals submit expungement applications and seal their court records. We were also able to provide financial support to those individuals, because despite what has been testified to that the cost is low, many could not even afford their application fees. And similarly, I would like to kind of do a shout out to the Hui Foundation, that they held an expungement clinic last year for the over 200 community members who were arrested for protesting at the Kahuku wind farms. So this again shows the continuing need for the people in our community to have assistance with expungement. And so an automated expungement, these individuals wouldn't have to wait, they wouldn't have to pay for relief. And a lot of times those that are eligible, they don't find out that there's something on their record, or don't realize that it's still on their record until something detrimental happens, like losing a job, not being able to travel to certain countries, or getting a rejection from a housing application.
Thank you very much. Could you summarize, please?
Yes, of course. So we would support this bill, and we would also support an amendment going one step further, which would also expunge convictions that would be pardoned, because that is not an expungible, even if you are pardoned, and those are pretty rare, the governor does not it does not allow you to have an expungement. And then, of course, Innocence Project and Beyond Guilt will be happy to provide any technical or legal support to see the objectives of this bill carried out. And thank you so much for allowing me to testify.
Certainly. Thank you very much for your testimony. Next testimony from Michelle Acosta. Nope. Okay. And we have written testimony and support from 17 other individuals. Anyone else here or online wishing to testify on this measure? If not, questions, members? Representative Ganadin, please proceed.
So Ms. Pooh, hey, good afternoon.
How are you?
I'm okay, at the Office of the Attorney General. What kind of resources did the Office of the Attorney General dedicate specifically to expungement?
That would be the Hawaii Criminal Justice Data Center. They are tasked with expungement. I just had recent experience with expungement myself personally. I had an abuse case that I reviewed maybe about a year ago with a defendant who is a realtor. And because she was arrested and I declined the case, apparently she was going through some sort of a background check proceedings and it was popping up in that background check. And she wanted to pursue an expungement. So she contacted me directly and asked me how to go about doing that. I referred her to the Hawaii Criminal Justice Data Center. I'm pointing to Phil because he's the director of it. And I told her she needed to go on the website. She was going to need to fill out a form and go through the process. She did so. I was contacted by an individual at the data center who wanted to confirm that we had in fact declined the case for prosecution. I provided that confirmation, and since then, her arrest was expunged. So that's my only personal experience with it. My understanding is it is a pretty simple process, but again, we are talking about arrests or other situations where the conviction has some other basis for being expunged. This bill is proposing to expunge actual convictions, which is a separate issue, right? Expunging past convictions is a separate issue. That's not ordinarily something that's part of expungement. There is a mechanism for that within the court system under 706-622.5 for first-time drug offenders. So there's a separate avenue for that specifically. So it's kind of talking about two different things at the same time.
All right, so it looks like, well, we're hearing, the Judiciary Committee is hearing several bills today regarding expungement.
Yes.
There are several states that have already passed similar versions of clean slate, and it seems like the sky hasn't fallen. Should we pass this? What kind of resources would the Office of the Attorney General require to process new requirements for expungement for previous convictions of, like, let's say, C felonies, marijuana charges, that kind of a thing? What kind of resources would you need?
To know exactly specifically what they would need, I'm not sure, but I'm hearing that they would need additional personnel as well as electronic database resources, because I'm not sure that they have the database system that can accomplish that.
You seem to be pointing to another gentleman in the back.
But I think that guy would know.
Thank you. I'd like to follow up with you, sir.
information?
Yeah, I mean, so.
My apologies.
Please come on up and introduce yourself and
I don't know
respond
if
to
you
the
would have
question.
that.
Yeah, so to reiterate the question, legislature's hearing several bills on expungement.
Yes, sir.
Several other states have processed it in a variety of different ways. We're looking at the scope of that expungement today, and what might be passed out of this, prospectively out of this committee. What kind of resources would you need should these bills be passed?
Sure. My name is Philip Higdon. I go by Phil. I'm the administrator with the Hawaii Criminal Justice Data Center. I'm responsible for the expungement section, which consists of one individual. There are the fees, what resources you ask. The fees that we collect for expungement and other fees like fingerprinting goes to support half my staff. It goes with purchasing new equipment, electronic equipment, computers, and so forth. So for the last 3 years, our expungement, the fees have collected approximately $40,000. So if we are just talking about this bill here that's being introduced right now, I would need to have supplemental funds for at least $40,000 a year in my general fund because I'm losing that money to support my personnel. Half my staff is not supported personnel costs under general funds. They're under the revolving fund. So that causes a hardship. You can give me more positions, you can allocate more money, but I'm going to be real honest with you. We are getting no applicants. People are not applying, or if they do, they're unwilling to come and interview. And that is just not the data center, that's the state, is what I'm being told. Finding people and keeping them is very difficult this time.
Wait, I'm trying to process. So you mean positions to fill in the?
Yeah, applicants for
Applicants, yes,
jobs.
sir.
Oh, job applicants.
Yes.
Expungement.
Not expungement.
No,
Okay.
no, I'm sorry, I apologize.
Yeah.
So if you're asking about resources and needing more people, needing more funding, we can't find the people that want the jobs.
Okay. Thank you.
Any other questions? I do have some questions. Let's see, for the, yeah, I think probably the, ma'am, if you could come up, please. We'll start with you. It was in 2019 that the legislature decriminalized small quantities, 3 grams, and yet so very few people have requested expungement from this offense. And it was in 2023 that the legislature passed a bill saying that the judiciary seal or remove from the judiciary's publicly accessible databases any information relevant to the arrest or case of a person for whom an expungement order has been entered and transmitted to the court. I understand that there's challenges in order to do this, but this is not a new request for having the judiciary and the Attorney General to work together to come up with a system that works. This year, I understand the judiciary is requesting in their supplemental budget an additional $170,000 to help go through this process of sealing expunged cases. It doesn't work for people when they come in and just ask. The petition process doesn't work. So we need to start a state-initiated process. So do you have a suggestion on how we can get some action out of the agencies to carry out what the legislature has already requested of you?
Are you asking for a process in order to get marijuana convictions expunged?
Well, the 712-1249, you asked, are we only focusing on cannabis? But I don't think that it's disaggregated in your data. Maybe you could respond to this, but in your data, if for convictions or for arrests of people under HRS 712-1249, I've been told that it's not disaggregated between what type of substance they have.
It does not.
So while our intention here is to have people be able to expunge their records for something that the legislature passed years ago to allow decriminalized 3 grams or less, your data doesn't allow us to do that. So that's why it's more broadly stated as anyone who has violated 712-1249, we're seeking to have that be expunged, because the database itself doesn't allow us to disaggregate it. So that's why we're doing this. Do you have a suggestion on how we can actually disaggregate the data?
It seems what you're suggesting is a 712-1249 as a violation and not as a petty misdemeanor offense. That should be more clear in the data collected by the judiciary as well as the data center. And if it is stored in that manner, it would be more clearly identifiable, because that would be the 3 grams or less amounts.
Could I ask, does the data allow us to distinguish that?
Currently, police departments are not required to give us that information on the drug or the drug amount, so that's difficult as
But
well.
what do we do to change that? Because we've got to improve this.
No,
People's
I'm not
lives
going
are
to
being
disagree with you,
messed
sir.
up.
It's all about getting the best information and the best data. But unless the requirements that if agencies are mandated to provide certain information, I think we can work towards that goal.
So who mandates what the police submit for their information? Is it you?
The statute is very, it just says that they will provide us information. Now, I don't know how the history of what was agreed upon for us to receive, but we're always asking for more data, more information. That's why there's 3 different committees or groups right now trying amongst police departments, prosecutors, defense attorneys, the health department, trying to understand and get that data. How do we get that information?
So who tells the police department what data to submit so that we can actually have the data that's necessary in order to effectuate what the legislature has already passed?
I think that's going to have to come from you folks.
We have to do that in statute?
I can ask, but that doesn't mean that they're required to. And to be real honest with you, sir, I don't know the steps of the law enforcement agencies on what is required when they fill out arrest reports and incident reports on it. Are they required to list the amount of drugs that were seized, what type of drug it was seized? I don't know. I can only assume that. She may.
Thank you. Yeah,
Yes.
please, if you can provide us more information, because I have to admit a high level of frustration
And I'm sorry.
that it's been going on for years and we don't have.
So the way
Any action?
a marijuana case typically comes in, a small amount marijuana case, is the prosecutor will review it. The way the case shakes out in the court system is what's going to control what goes over with finality to the data center. That's how it's supposed to be. So if documentation were provided to the data center via this application process that we've been talking about in our testimony that states that this was a violation and not a petty misdemeanor, it would be easy to provide.
But let me interrupt you. I'm not trying to perpetuate a petition-based system. I want the state to initiate this. So what will be required for the state to have the data to know that they need to initiate an expungement process? I'm not asking for, because people are not going to come in and give a petition. It doesn't happen. So we need to figure out another way of doing this.
Okay, I can't answer that today,
Well,
sir.
this is what I really would like to have some assistance from the judiciary, from the Attorney General, to figure out how to make this work. And you can't just say we don't have the data. We've got to figure out how to fix it. So I appreciate that you can't tell me right now how to fix it. But this is not new. Maybe this committee's emphasis upon expungement is new, but there's been acts by the legislature to make
I've
it
seen
clear
them.
that this is something legislature wants to happen. So I apologize for my frustration, but I think that's merited.
Understood, sir.
Other questions, members? Let me ask the public defender briefly.
Did you have a question for me, sir?
No. Oh, did you want to follow up with?
Is Karen O'Keefe here online?
So, ma'am, thank you very
Sorry.
much.
Thank you, Ms.
We'll switch over to Representative Ganadin. Please, go ahead.
Is Ms. O'Keefe here from the marijuana?
She was on Zoom? Nope, she signed off. She's not on.
Is Frank Stiefel here?
Frank Stiefel,
Still here?
please proceed.
Yeah, I'm here.
Hi.
Hello.
Yeah, thank you for your advocacy and thank you for continuing to zoom in. Let's see. As the chair noted, we have come back several times to urge the Office of the Attorney General and the judiciary to move forward with essentially a government or state sponsored process by which individuals can expunge their previous criminal records having to do with cannabis or low-level misdemeanors. To your knowledge, what are other states that are currently doing this process?
Yeah, as I mentioned in my testimony, there are dozens of states over the past few years that have passed laws to create these state-initiated processes specifically for cannabis-related records, right? But then if you take even a broader look at the landscape, there are many more states that are passing these, what we call these clean slate laws, and the eligibility, and that's also, right, a state-initiated, automated expungement process. And those clean slate laws, right, encompass a lot more convictions and records, right, outside of just cannabis, right? So you're not only seeing that there are tons of states, right, that are passing these clean slate laws that, has a broader eligibility than just for cannabis records, but then since, right, 2018, 2019, you're seeing 13 states, right, including, Minnesota just recently, that are passing these laws to create state-initiated record clearance processes specifically for cannabis. And I think what this bill and what Rep. Tarnas's bill is trying to achieve right here is piloting, right, the creation of this state-initiated process specifically for cannabis records, right, in the hopes that it can, I think, alleviate a lot of the concerns and issues that have been raised by Rep. Tarnas in his questions, right, and the fact that it does seem like there are a lot of improvements, right, that need to be made to the expungement process so that people who are actually eligible to receive expungement actually get it. The data shows, right, that those individuals are not receiving it. And so I think this bill will actually ensure that that occurs. So this is not new. And yeah, I think it's, time for Hawaii, to join the cause for sure.
Thank you.
Thank you. And one question more for the public defender, if I may, Mr. Lowenthal. Let me just throw you a softball. What would you do to improve the system so this would actually work with the state-initiated expungement process?
I think arrest records are kept by prosecutors from all the counties. In my experience, the arrest record number is what tracks. It's usually on the charging document. It also is a key number because prior to the case being charged, that is the tracking number. And so you do have expungement issues where no charges were filed at all. How do you keep track of that? It would be the arrest number. It's just from hearing the back and forth. I do think that is that does seem to be the number that I, in my experience as a public defender and criminal defense attorney, have seen. And that seems to be a constant throughout the life of a case.
Let me just lay out some of the opposition I've heard is that if we don't have it initiated through petition, we won't have the address of the person to send them their mugshot or their fingerprints or things. I don't, in my opinion, in my mind, the priority is not to return the mugshot and the fingerprints to the individual, it's to expunge the record. That's actually what we're after.
Yes.
So you don't need the address to expunge the record. Am I accurate in that approach?
Again, and I can only speak from my experience as a criminal defense attorney, in a lot of cases, the issue is not so much. I think what's happened is in the pre-electronic age, you would literally get your photographs and your fingerprints and the physical things that happened during the booking process would be returned to you. And what I've seen over the years is as we become more automated, that becomes, again, yes, that becomes less important. What becomes far, far more important is the fact that employers and housing associations and all sort of other people and entities and institutions that we have to live with have access online and a hit comes up of some kind. And so it's not so much the returning of the physical materials as it is to seal, as it is if there must be a place to hold it somewhere. That's just, I believe that is a secondary concern for our former client's perspective. It's more about closing off access from potential employers so that they see a flag or something to that. Now, I will say the certificate of expungement is important because we can advise our client at that point that when they fill out the application, have they been arrested, they can then present the certificate. But that becomes tricky on the way the application is worded.
Okay, well, we still have a lot more work to do on this. I appreciate everyone's testimony. I apologize for my frustration, but first time at Judiciary Chair, I'm just astounded that we don't have a system set up already for this. and the data isn't organized in a way. I'm a data guy, and it's like, we should be able to figure this out, and it's not a laughing matter. These are people's lives that are being ruined because of this. So we got to figure this out. So I really implore the judiciary and the Attorney General to work on this together. We've got to figure out a way forward on this. So enough of my speech. Go ahead, Representative Gannon.
One follow-up to Office of the Attorney General and so yeah, both of you folks. Sorry. My experience as being an attorney is I often go on the Jeff's website to look up a case ID number. Sometimes I use the arrest number to track a case for a defendant who I am representing, usually as a court-appointed attorney. There's also the public records under e-court COCUA. Would it be that difficult to process individuals through a state-initiated process, like possibly an online process by which you could check their identification or do some other thing, have them file a motion? We do similar things with restraining orders and all kinds of things where you don't have to show up in person anymore. And then simply delete the record off of the publicly accessible e-court COCUA. Would that be very difficult?
Well, the Hawaii Criminal Justice Data Center has, that's the judiciary's websites. We have no control over that. We only control arrest information, not conviction information. So it's important to know that we, the Hawaii Criminal Justice Data Center, can only expunge arrest information, not conviction information. That has to come from the judiciary, a court order. Once a court order has been given, then we receive that and then we expunge it. So the GEMS and the e-court COCUA, we don't have any control over.
So we'd have to work with the judiciary to expunge via e-court COCUA.
Yeah, for convictions, yes.
So for arrests.
Yes, sir.
Especially if they didn't result in a conviction.
Right.
Where, people get arrested all the time or an incident happens and officers get it wrong and, we have a whole very robust constitution that protects individuals before the court system. Would it be that difficult to just simply delete the record?
Well, we're mandated by state statute to do a few things, okay? And one of them is we're required to, a written application has to be submitted, and we're required to issue a certificate of expungement. So just kind of, if I may, just kind of give you a brief overview of how the expungement process works. The application comes in, my staff reviews it, they research to make sure everything within the RAP or the Criminal Justice Information System is correct. If there's something missing, there's no disposition, they will contact the courts. They will actually reach out to the police departments as well to try to update the information to determine if the offense, the arrest, can be expunged. That is a manual process. That cannot be automated. Once they determine that the individual can have an expungement, then a letter is drafted for me to sign that I send to the police departments or law enforcement agencies requesting any photographs or fingerprints that they may have on this individual for this arrest be turned over to us. Once we receive that, then we mail that information, and I know a lot of things are automated, but we're still getting mug photos and fingerprints that the agencies still have. Once we receive it, then that's why it's so important to have that current address so we can mail that confidential information to the individual that was arrested, as well as their certificate.
Can you just destroy it?
State statute won't allow us to destroy it. We're mandated to issue a certificate and return any mug photo or fingerprints related to that arrest to that individual.
Okay, any other questions, members? Thanks, I think we've spoken.
It can be wiped from the judiciary website, though. I've seen it happen. I went back to look for a case, and it's gone. So it's possible.
Okay.
Well, that gives me hope that this whole thing is possible. So we've got to figure out a path forward. So anyway, thank you for all those questions. I appreciate the committee's forbearance with my questions. Let's move on to the next measure. House Bill 1663. This relating to expungement of criminal records expands the eligibility for and automates the expungement of conviction records if certain criteria are met. Beginning in December 2026, requires the Attorney General to issue automatic expungement orders and the judiciary to seal or remove information from publicly accessible databases. First up, Attorney General in opposition. Please proceed.
Good afternoon, Chair Tarnas, members of the committee. I'm Deputy Attorney General Albert Cook, again from the Criminal Justice Division. And as laid out in the testimony, the Attorney General, the department is just opposed to automatic expungement, period. That's kind of our position. We've laid out in our testimony a number of reasons why we think that automatic expungement is not a good idea, including that law enforcement, the judiciary, landlords, employers do need to know the criminal history of people that are applying or that are involved in the criminal justice system. So because of that, just as a policy matter, we don't think automatic expungement is something that we can support. There are also a number of technical reasons why we're opposed to that, which I think Mr. Higdon has already outlined, and I think that's part of the other testimonies as well. Specifically with this bill, the time limits for automatic expungement for like all petty misdemeanors and misdemeanors of 5 years, and then for all nonviolent C felonies of 7 years, we think is problematic as laid out in our testimony. There are a number of situations where that's going to result in people having their records expunged while they may be pending trial for another crime that they've committed within that 5 years. And because of that, they would be repeat offender sentencing eligible, or for those who are on probation currently, and then while they are on probation and their probation extends past those windows, they could have their convictions automatically expunged while they're still on court supervision. And there's a number of different situations where having the automatic expungement within those 5 or 10 year windows is problematic. Our other reasons are laid out more fully in the testimony, so I am available for questions later.
Great, thank you very much. Next, we have testimony in support from the Office of the Public Defender.
Good afternoon again. We support this bill, and I want to use my time to take you back to the Maui waiting room of the Public Defender's Office. And I can tell you with regularity, we have what I would call orphaned clients, people who are not assigned to any active case, some people who haven't stepped foot in our office for decades because they found out that their arrest record is still there, that it's hindered their ability to get housing, to get a job, for something that happened to them when they were kids. And we're talking about grown men and women with, who have thought that they had paid their debt or moved on. And it's not just the arrests. I also want to share that, you know, a big chunk of people who are entitled to expungements are those who've been arrested, charged, prosecuted, gone to trial, and found not guilty. And should a landlord know that and use that as a basis? We say no. And that is why we support these steps to make this propelled and automated by the state, as opposed to on the applicant who may not foresee these things. And I do agree, it is a two-step process. You need to get the police on board with the arrest records. It's also equally important for the judiciary to seal these records. And I will just briefly say, it is difficult now because not only do you have to get the conviction, or say the conviction is wiped clean through some sort of diversion process, or maybe you have a not guilty verdict. That's on the court end. Then you deal with the expungement, and then you sometimes will have to go back to court to file this motion to seal. So you have a multiple processes, multiple steps. And again, I'll point out that our deputies are not supposed to be covering this because it's no longer part of the criminal case. They're expected to do it on their own or hire an attorney. So that is why we support this bill. Thank you.
Thank you very much. Next, we have testimony with comments from the judiciary.
Yes, good afternoon again, Chair Tarnas, Vice Chair, members of the committee. Thomas Berger, Staff Attorney for the Hawaii Supreme Court. I do want to just sort of reemphasize that the judiciary does share the committee's concerns about simplifying the process for self-represented parties. So currently, if a party gets an expungement certificate and they want to seal a case, all they have to do is file just one sentence, like a letter saying that they have the relief and attach the expungement certificate. So the judiciary has made it quite easy in terms of the paperwork to make the request to seal the records. So we certainly share the committee's concerns about trying to identify a state-initiated way to have that motion come before the court. I don't need to go over all the other concerns, but just to kind of quickly touch them, it's really important that whatever the bill is, it doesn't limit judicial review and discretion. That's definitely important. And then certainly, it's going to have operational impacts to the judiciary and significant costs. And that's something that I would like to emphasize. And thank you for the opportunity to testify today.
Thank you very much. Next, we have testimony in opposition from the Crime Victim Compensation Commission, Pamela Ferguson Gray. Testimony in opposition from the Office of Prosecuting Attorney. Testimony in support from Community Alliance on Prisons.
Aloha again, Kat Brady testifying for Community Alliance on Prisons in strong support. You know, there are many states who have clean slate laws, and we should be one of them. We were at a conference in October, and it was reported that 75% of all the people in Hawaii's jails and prisons are in for Class C felonies and below. What are we doing for $254 a day? This is just insane. So clean slate is something that is being practiced all over the continent. Automating record clearance processes for eligible people. Automation must be retroactive, and when possible, expand the number and types of offenses that are included. Consider decreasing the period for an individual to wait before any kind of record clearance. And there are many other states. I was talking with people from Virginia, and I was talking to somebody, a local person, about expungement. And I said, wow, I'm having such a hard time. They can't afford an attorney. And she said, what? What do you mean an attorney? And she said, I'm an attorney in Virginia, and we do automatic expungement. And other states do that. Why are you so punitive? I said, I don't really know why we're that punitive. But I just want to remind everybody, we have an Aloha Spirit law. And one sentence in there is so beautiful. Aloha is the essence of relationships in which each person is important to every other person for collective existence. So let's think about our community, and let's act like a community. Mahalo.
Thanks very much. Next, we have testimony in support from, testimony in opposition from the Sex Abuse Treatment Center.
Good afternoon, Chair Tarnas, Vice Chair Takayama, and members of the Judiciary and Hawaiian Affairs Committee. My name is Lynn Costales Matsuoka. I'm the Executive Director of the Sex Abuse Treatment Center. We are in opposition to this bill as it appears to cast a wide net over offenses involving sexual offenses, many of those covered by our sex offender registration laws under Chapter 846E, which have much longer registration periods than those, than the 5 years and 7 years as proposed by this bill. Some people would get their records expunged despite the fact that they are still required under Chapter 846 to continue their registration. Some of those offenses in which require registration and would be covered by this particular bill include offenses against children, sexual offenses against children. Some of those require lifelong registration. And for those reasons, we are opposed to the bill as it relates to sex offenses, crimes against children, and those sex offenses covered by the sex offender registration law. Thank you very much for an opportunity to testify today.
Thank you very much. Next, we have testimony from Michelle Acosta. Please proceed. Michelle Acosta. Oh, no, sorry. Next, we have testimony from Alice Liu. Please proceed.
Aloha Chair Thomas, Vice Chair Takayama, and members of the committee. My name is Alice Liu, Program Director at Mothers Against Drunk Driving Hawaii. MAD represents drunk and impaired driving victims and survivors. I stand by my written testimony and oppose House Bill 1663. I'm available to answer any questions, and thank you so much for the opportunity to testify.
Sure, thanks for testifying. Next, we have testimony from the Last Prisoner Project, Frank Stiefel.
Yes, hello again, everyone. Frank Stiefel with the Last Prisoner Project. I just want to acknowledge the capacity issues and the infrastructure concerns that the judiciary and the AG's office have brought up in automating the expungement process. But I think it is clear from this hearing that the expungement process in Hawaii must be updated to be more in line with the rest of the country and best practice. So I know that folks have asked me for specific numbers related to states that have, passed these expungement laws. So since 2018, 13 states have passed state-initiated record clearance processes for cannabis records. And then more broadly, 13 states have passed clean slate bills, which have a broader eligibility scheme for an automated expungement process. And again, I just want to reiterate that the responsibility to identify and clear eligible records should fall on the government instead of the individual. And this is just based on national best practice, right? And also obviously the data in Hawaii as well that shows that less than 7% of people who are already eligible for record clearance never receive that relief because of how cumbersome the record clearance process is. So for that reason, we support HB 1663 and we'll be here to answer any questions. Thank you again.
Thank you very much. Next, we have testimony from Jen Brown, Hawaii Innocence Project.
Thank you so much for allowing us to testify again in strong support of HB 1663. I kind of reiterate the points raised by ACLU and MPP and LPP in their testimony. And we also reiterate the testimony that we provided on the other expungement bill, HB 1595. We again would suggest we like the bill as it is, but if you were to add any amendment, I think we would like the committee to consider also the possibility of expunging pardons. They are rare. If a governor pardons someone, it is a very rare occurrence, but a lot of pardoned individuals are under the assumption that that means their conviction would be expunged, but that's not what the law stands. The state constitution gives the power to the legislature to actually go further than our current clemency laws. I also was in listening to the testimony by the AG and the judiciary and the Hawaii Criminal Justice Data Center. My understanding of the process as it is that if somebody has a conviction and they're eligible for an expungement, the court has to prepare that order. Now it requires the applicant to actually get that order from the court, submit it with their application to HJDC. But it seems like in some way to automate that would be what they've done in other jurisdictions, which is basically setting like an administrative hearing at the time that the person is off probation or has completed all the conditions of their conviction, and do basically a file check with which potentially the court could then send the order CCing the other agencies like the police department and the prosecutors that they have ordered a conviction to be expunged, sending that order to HJDC, and then also instructing, obviously, these other agencies to submit their files and records. I do believe, and I may be wrong, but my understanding is the Hawaii Criminal Justice Data Center also is kind of the archival space for these files from these various agencies. So, I know there's a concern about mailing these documents and not having the appropriate mailing address, and that's what is the application piece of it. But it seems like if they're already kind of housing these documents that pursuant to an expungement, why not house it and allow that person to reach out to the Hawaii Criminal Justice Data Center if they should ever need their expungement order, or if they want those files and records for their own records. So it's just one thing that I kind of wanted to comment on, and thank you very much.
Thank you very much. We have testimony from Dennis Dunn. Please proceed.
Thank you, sir. Good afternoon, Chair Thomas,
Representative Takayama, and members of the House Committee on Judiciary and Hawaiian Affairs. My name is Dennis Dunn. I'm the retired director of the Victim Witness COCOA Services in the Honolulu Prosecuting Attorney's Office. It is my over 45 years of assisting crime victims that I'm testifying in strong opposition to this measure. The provisions of House Bill 1663 would create automatic expungement of convictions of most petty misdemeanor and misdemeanor offenses, including domestic violence, sexual assault, and stalking, and most Class C felonies. I'm unclear as to the origins of this particular measure, but it's clearly a very bad idea. My initial concern is simply that many offenses covered by this measure could involve crimes that involved acts of domestic violence, sexual assault, and stalking, among other serious crimes. While an individual may enter a guilty plea to an offense that may appear to be less serious in nature, such as harassment, the underlying conduct may be much more serious. For this reason alone, automatic expungement would not be prudent, as without scrutinizing the specific details or facts of an underlying case. Of equal concern is the fact that many criminals' histories of acts of domestic abuse, sexual violence, and stalking may have committed many other offenses involving these same types of acts without a criminal conviction. So even though time has passed, that doesn't mean that this person needs to have their past convictions expunged, because they may be involved with the same kind of conduct over time. Oftentimes, there may be no subsequent convictions because of victim intimidation, victim disillusionment with the criminal justice system, and in situations with the length of time taken to get the matter to trial may have resulted in victim or other witness relocation, loss of interest, or even the death of a key witness. The lack of subsequent or concurrent convictions may clearly not mean that an offender is not a current or future danger to other potential victims or to the public. Automatic expungements would deprive us of the ability to properly scrutinize and access the past behavior of individuals and may put us all at risk. Additional factors that should be considered when evaluating the merits of the provisions of House Bill 1663 excuse me, would be the impact of the provisions of the bill may have on the requirements of the sex offender registration statute, or other statutes would have look-back provisions such as DUI and so on that can involve enhanced charging or sentencing as established by the legislature for certain types of crimes. Not only are there obvious concerns about potential safety implications posed by automatically expunging offenses, but a myriad of administrative and fiscal impacts that would result. The large number of offenses that would need to be expunged under this measure would undoubtedly create an administrative nightmare and would be severely tax agencies that are already overextended and understaffed. This simply makes no sense to me. We must retain the ability to accurately assess offenders and limit any type of ability to expunge criminal convictions to only those offenders who clearly
Thank you.
merit
You want to
such
summarize,
consideration.
Mr. Dunn? That'd be great.
Clearly at their expense. In summary, I'm asking you to hold this measure. One other quick issue, I believe that there are concerns also that this may impact victim receiving restitution. If a matter is expunged and there is no further action taken on the case, the victim may lose out on their restitution, and that is a major concern of mine. Thank you.
Thank you very much. Next, so we have testimony, 15 people in support, 9 in opposition. Are there folks here in the room or online that would like to testify? Ms. Mercado. And then I'll come over to you. Please introduce yourself and please proceed.
Good afternoon, Chair, Vice Chair, committee members. I'm Angie Mercado, the Executive Director of the Hawaii State Coalition Against Domestic Violence. On behalf of our 27-member program statewide, we are in opposition of this measure, and we respectfully recommend that it be deferred. Some of our significant concerns with this measure relate to specifically domestic violence offenses, which are classified as petty misdemeanors under a pilot project currently with the prosecutors. They can also be misdemeanor charges as well. We're concerned especially about stalking charges. Aggravated stalking is a Class C felony, but we know that stalking behavior is very much linked to sexual violence, so we're concerned that these are going to be automatically expunged and not considered. Another point as well is that we actually have in our state a domestic violence fatality review that was created in statute that allows us to look at past criminal activity and convictions when we're reviewing a fatality to make systemic recommendations, and there's no provision in this statute that would allow us to be able to have access to that. This legislation also does not take into consideration waiting periods, so if there's somebody with it who has a current charge pending, what might happen. And then finally, to Mr. Dunn's point, we are concerned about what may happen with pending restitution, any other kind of payments that are due to for crime victim compensation. This measure does not address that and what may happen, especially if there's a look-back period that may be longer or restitution payments are longer than what's provided for in the look-back periods in this measure. That's it for me. Thank you for this opportunity to testify on behalf of all victims of crime in Hawaii.
Thank you very much. Mr. Rhoda, on behalf of the ACLU, please proceed.
Aloha. We strongly support this measure, which we're going to call clean slate more broadly. A number of things have been said today. I want to touch upon some data, but also share a few stories, and then also address some of the concerns that have been raised by stakeholders in our community. We know that by seminal literature shows that there are over 50,000 restrictions that people face once they have a criminal record. Could be arrest that never resulted in a conviction, an arrest, someone went to trial, found not guilty, or even a conviction. 50,000 restrictions. That means less access to jobs, housing, other life opportunities. And so if we do not provide people meaningful opportunities, second chances to change their lives, to provide for themselves and their children, then essentially what we're doing is pushing people to revert back to criminal activity. And then we wonder why they're returning to that lifestyle if all of these barriers are in place. In the digital era, nearly 9 in 10 employers, 4 in 5 landlords, and 3 in 5 colleges now use background checks. It's everywhere. Now I want to talk a little bit about some of the logistics. I've heard a lot of frustration, I think, from everyone, recognizing that we have 2 repositories of criminal records. We have the Hawaii Criminal Justice Data Center, and then we have the judiciary. What we really need is a massive whiteboard and for all the stakeholders to show how it works together, because I think what was very clear is that no one really knows this whole labyrinth of how these processes work together. That different stakeholders have different information. We need to come together and figure out a solutions to move forward. And other states have also faced difficulties in siloed repositories. I'd like to point out that we have currently 12 states that mean Clean Slate Initiative eligibility: Pennsylvania, Utah, New Jersey, Michigan, Connecticut, Delaware, Virginia, Oklahoma, Colorado, Minnesota, New York, and California. And that's just in the last 5 years. I've actually spoke to some people who have worked with other states that have implemented Clean Slate. And the reality is that it's a struggle because these systems don't work together. The good news is that Clean Slate Initiative is a national organization. They can work to provide technical assistance to states that may be contemplating and implementing Clean Slate. There's also another nonprofit organization called Code for America. They're the IT techie folks. They actually help states create these IT systems to implement Clean Slate. And so I think if you look at this bill in other states, this won't automatically occur. We need to work together, give it ramp-up time for the different agencies to have the time to study, to implement, to work with IT folks, and to have it implemented. And I also just want to highlight, we hear some of this, we've heard from the domestic violence organizations, criminal victims, and I think that's really important. I want to be fully candid. If you look at the number of states, they have various eligibility for what falls into Clean Slate, what does not. The time frame for period of expungement varies from anywhere 4 to 7 years up to 10 years. But I think, again, it goes back to at what point do we stop punishing people for past behavior? At what point do we allow people to move forward in their lives? And the flip side, there are a number of women, 85% or more of the women in our jails and prisons are victims of domestic violence, sexual abuse, other violence. I've worked with them. And I can tell you, they also are impacted by the fact, these barriers. There was one woman on the island of Maui who was in our program, went back to school, turned her life around, a single mother, obtained her certified substance abuse treatment certificate. She finally was lucky enough to earn a housing Section 8 voucher, and she was going to be disqualified because of a past conviction years ago. So this bill, if you pass it, will help women who oftentimes may stay in relationships in part because they are financially dependent upon their abusers. And so I think we need to look at the broader side of this, and we try to figure out a win-win. So if there are certain charges that ultimately this committee decides to exclude, I think that has occurred in other states. And I also want to point out another gentleman in our program, Native Hawaiian, had drug charges in the past. He went through all the hurdles. He had a deferred acceptance guilty plea, allegedly got it sealed, got his double bachelor, Olelo Hawaii, Hawaiian language, biochemistry. Went out of state, continued his education, wanted to get a certification in massage therapy. Again, drug-related charges when he was younger. And when he's in California, flags pull up. All his past charges that were supposed to have been sealed and expunged came back to haunt him. And I think that's the opposite of what we're doing. Let's work together. Let's focus on solutions. And I trust that Clean Slate Initiative, other states, and Code for America are willing to work with us to find a solution forward. Thank you.
Thank you very much. Is there anyone else here wishing to testify on this bill, House Bill 1663? If not, questions, members. Rep. Gandon.
Thank you, Chair. I'll try to be brief to the judiciary. Back. Mr. Berger, you still there?
Yeah, Mr. Berger's there, yeah? Mr. Berger?
Can you hear us?
Go ahead, Mr. Representative Ganadin.
Okay, check my 1, 2. I was just handed a copy of the current version of HRS 831-3.2 regarding expungement orders, which is the law that we're discussing today. I forgot about a bill that we had passed last year that says in Section F, the court shall make a good faith, diligent efforts to seal or otherwise remove applicable files and information within a reasonable time. While we were hearing copious testimony today, I actually looked up the judiciary's site and the steps that it has taken, including sending people to the Hawaii Criminal Justice Data Center, which is here before us today, as well as the second step, which is how to seal court records. I guess my question to Mr. Berger is, why do we need this second step if the first one seems to suffice and is now mandated by statute?
Mr. Berger, could you unmute yourself and see if you could respond to Representative Ganadin's question?
Okay.
Okay. Technical difficulties. Let's just give him, we'll give him 30 seconds.
Yeah, it's no big deal.
We'll give him 30 seconds. If he doesn't, if he's not able to reconnect, then we'll have to move on. He's not coming back? Okay. We'll have to follow up with him.
Thank you.
Thank you. Any other questions? If not, let's move on. Thank you to all the testifiers. Let's move on to the next measure. HB 2513 relating to expungement. This allows persons convicted of certain criminal violations to apply to the court for an expungement order under certain circumstances. First up, we have testimony from the Attorney General.
Good afternoon again, Chair Tarnas, members of the committee, Deputy Attorney General Albert Cook from the Criminal Justice Division. And we thank you for the opportunity to provide comments on this bill. So basically, this bill takes the OVUI convictions if somebody is under 21 and consumed a measurable amount of alcohol. So we actually don't have any problems with that section of the bill. That seems to legally and constitutionally be fine. Part 3 of the bill seeks to do the same thing for those who are convicted. If they had been convicted now, would have been under the first-time property offenders. and would have been had a process to be expunged under that, and makes it, tries to make it retroactive within a certain date range. And because of the nature of the first-time property offense program, you know, the whole purpose of that is for rehabilitation, and so there's a bunch of steps that they need to go to make sure that their substance abuse issues are taken care of and they complete the program before they can have it expunged. So we've suggested language so that the elements under the current first-time property offender statute would be able to be applied retroactively. I'm available for comments.
Thank you very much. Next, we have testimony from the Office of Public Defender.
Good afternoon. Public Defender supports this, supports the bill, and we believe that people do deserve a second chance. This goes about doing just that. We would like to see it expanded to other types of offenses and other age groups. It is a good step forward. We are available for questions. Thank you.
Thank you very much. Testimony with comments from the Department of Transportation. Testimony in opposition from the Crime Victim Compensation Commission. Pamela Ferguson Bray. Testimony in opposition from Alice Liu. Please
Aloha, Chair
proceed.
Thomas, Vice Chair Takayama, and members of the committee. My name is Alice Liu, Program Director at Med Hawaii. I stand by my written testimony and oppose House Bill 2513. I'm available to answer any questions, and thank you very much for the opportunity to testify.
Sure, thanks for testifying. Next, we have testimony and support from two organizations, Cannabis Society of Hawaii and ACLU Hawaii, and two testimonies in support from two individuals. Is there anyone else here wishing to testify on House Bill 2513? If not, questions, members? If not, thanks very much. Now we're going to move on to something completely different. I really appreciate the tax department for being so patient. I apologize that you had to sit there the whole time. So let's move on with all due speed to House Bill 1806 relating to the procedure for tax appeals. This measure removes language specifying that an appeal from the tax appeal court be filed with the tax appeal court. Allows an appeal from the tax appeal court to be filed within 30 days of entry of a final judgment. First up, we have testimony from you didn't testify on this one. Okay, we have testimony from Tom Yachika, Tax Foundation of Hawaii. Please
Thank
proceed.
you, Chair, Vice Chair, members of the committee. Tom Yamachika from Tax Foundation of Hawaii. The reason for this bill is an anomaly created by a Supreme Court case called Alford versus City and County of Honolulu. What the case held was that tax appeals are different from other appeals. You don't appeal from a final judgment. You can appeal from a decision, which is less than a final judgment because it doesn't dispose of all the claims or all the parties. Litigators like me get confused over stuff like this, and this bill is an attempt to make it less easy for the department to win by technicality, so that litigants who want to appeal can do so either from the date of decision or from the final judgment into which it's merged. I'd be happy to answer any questions.
Yeah, so does that mean you think it's a good idea?
Yes.
Okay, thanks. Testimony and support from James Yuda. If not, any other testimony on this measure? Questions? Okay, we'll move on. Mr. Berger, I appreciate you're back on. The Representative Ganadin has already left, and so I think we're going to need to follow up with you offline. But I appreciate you. I appreciate you coming back. But we'll follow up with you offline. Thanks very much.
Happy to do that. Aloha.
Okay, aloha. Okay, let's move on to the next measure. House Bill 2485, relating to state tax administration. This eliminates an obsolete fee for a certified copy of a tax clearance, adds a penalty for failure to comply with reporting requirements under general excise law, and transient accommodations tax law for collection of rent by a third party, raises the unfair competition penalty under general excise tax laws to adjust for inflation. First up, our very patient director, Gary Suganuma, or his representative.
Good afternoon, Kristen Sakamoto, Deputy Director of Taxation. The department supports this administration measure and thanks the committee for putting it on the calendar. There are three components to this bill. The first is a simple cleanup provision. The second amends provisions in GET and TAT law that currently require persons who collect rent on behalf of an owner of real property, both short-term and long-term rentals, to make certain disclosures regarding tax obligations and provide contact information for the owners to the department. The law currently does not provide for a penalty, so we are proposing to impose a $500 fine for each violation in hopes that this will increase tax compliance with this law. The third part of this bill just increases the penalty for unfair competition. The penalty is $50 per offense, which has not been changed since the law was enacted in 1935. So to act as more of a deterrence, we just propose that the fine be increased to $1,000. Thank you again for hearing this bill.
Thank you, Deputy Director. Next, we have testimony, the comments from Tom Yamachika.
Thank you, Chair, Vice Chair, members of the committee. Tom Yamachika from Tax Foundation of Hawaii. We will stand on written testimony and be available for questions.
Thank you. And testimony and support from Tamara Paulton. Anyone else wishing to testify on this measure, HB 2485? If not, questions, members? Seeing none, let's move on to the next measure, 2486, relating to tax enforcement. This measure authorizes the Department of Taxation to serve administrative subpoenas outside the state. First up, we have Deputy Director Kristen Sakamoto. Thank you for your patience.
Thank you, Kristen Sakamoto, Deputy Director of Taxation. Thank you again for hearing this measure. The department supports this administration measure. It allows DOTAX to serve admin subpoenas outside the state. It's primarily meant to target out-of-state businesses that engage in business in the state but don't have a physical presence here. In the age of a lot of internet commerce and e-commerce, there are a lot of businesses who sell things into Hawaii, do business here, but don't have an agent for service of process here. So we would like the ability to serve witnesses and taxpayers outside the state, and that is exactly what this bill would accomplish. So thank you very much.
Thank you very much. Next testimony from Tom Yamachika. Please proceed.
Thank you, sir. Members of the committee, Tom Yamachika from Tax Foundation of Hawaii. We will stand on a written testimony and be available for questions.
Thanks. Anyone else wishing to testify on this measure, HB 2486? If not, questions, members? Seeing none, let's move on to the next measure, 2487, relating to tax enforcement. This provides deadlines for taxpayers under audit to comply with demands to produce documents and evidence, authorizes the tax appeal court to preclude documents or information not produced pursuant to a demand from being introduced in evidence in a tax appeal or action under Section 40-35, unless the failure was due to reasonable cause. First up, we have testimony from the Director, Gary Suganuma. Welcome, sir.
Good afternoon, Chair, Vice Chair, and committee members. Gary Suganuma, Director of Taxation. The department strongly supports this administration measure, and this measure is really to address those taxpayers that are under audit that fail to cooperate and provide information needed by the department in order to conduct the audit. And so what this measure seeks to do is it seeks to discourage such conduct by taxpayers by imposing a deadline for taxpayers who are under audit to respond to a written demand or request from the department or from the auditors, and they need to respond by 20 days. And then also it prohibits taxpayers that fail to comply with the department's written demand for records from then using those records later on in a subsequent court proceeding. What we've seen and what happens is that taxpayers will basically ignore the request during the audit or otherwise not provide information. And the department then spends time and resources to do an assessment based on the best available information. taxpayer will appeal it, and then in a subsequent proceeding, seek to then, for the first time, furnish the records, which sometimes, basically it's exculpatory, or it basically demonstrates that they're not subject to tax, or it limits their liability. And, so the case resolves at that point. But then in the meantime, the department spends a lot of time and resources doing this. And so this is just to incentivize taxpayers to provide the documents upfront during the audit. And in some of these cases, we believe that it could resolve the case much sooner and not need, and render a subsequent court proceeding unnecessary. Thank you.
Thank you very much. Next, we have testimony in opposition from Richard McClellan. Next, we have testimony, comments from Tom Yamachika.
Thank you, Chair, Vice Chair, members of the committee. Tom Yamachika from Tax Foundation of Hawaii. We see a lot of problems with this bill. First, the bill purports to tell the judiciary what is and is not admissible evidence. Can't really do that. The judiciary has their own rules, they have their own procedures, and they're constitutionally allowed to make their own rules that have the force and effect of law. Secondly, we have a problem with the 20-day deadline specified in the bill. It's completely arbitrary. Certainly, there's going to be more time required if you are serving a 100,000-page request than a 10-page request. But the deadline is the same in every instance. We also have other technical concerns that are in our written testimony, and we'd be happy to answer any questions.
Thank you very much. Is there anyone else wishing to testify in this measure, 2487? If not, questions, members? No, okay, we'll move on to 2488, relating to the Taxation Board of Review. This amends the minimum qualifications for the chairperson of the Taxation Board of Review. First up, we have testimony from the DOE Tax Director, Gary Suganuma.
Hi, good afternoon. Gary Suganuma again, Director of Taxation. This measure seeks to resolve or address a problem with staffing the new paid Board of Review. So previously, the Board of Taxation Review was a volunteer board. And then through legislation passed in 2022, effective January 2023, became a paid board, a 3-member paid board that would be appointed by the governor. Our understanding is that there've been a lack of applicants for the board positions, and therefore the board has not been appointed yet. And so our understanding is that there may be accountants and other tax professionals that may be willing to serve as the chair of the board, except that right now, I guess the requirements could be read as requiring someone who has an active state bar license or a CPA license. And individuals that may want to or may be interested in taking the board position have expressed that it is costly and somewhat burdensome to maintain at least a CPA license, and it is costly for the bar license. And so, because the license really isn't required for them to serve as a board member, we wanted to sort of relax that rule. And we believe it's more important for candidates to, either be, I guess it's more important for them to demonstrate they have Hawaii tax experience. And so that's what we're seeking to do. And with that, we hope that this would open, this would encourage more applicants, and we could fill the board seats. Thanks.
Thanks very much. Next, we have testimony from Tom Yamachika, Tax Foundation of Hawaii.
Thank you, Chair, Vice Chair, members of the committee. Tom Yamachika from Tax Foundation of Hawaii. We'd be happy to stand on written testimony and providing comments, and we'll be available for questions.
Thank you. And next testimony in opposition from Richard McClellan. Anyone else wishing to testify on this measure? If not, questions, members? Seeing none, we'll move on to the next one, HB 1805, relating to the procedure for payment under protest lawsuits. This allows for the interest earned on payments under protest in the litigated claims fund to be paid in non-taxation cases if the claimant prevails. Establishes a procedure for the disposition of monies and refiling of actions when a payment under protest suit is filed prematurely. First up, we have testimony with comments from the tax director, Gary Suganuma.
Gary Suganuma, Director of Taxation. The only thing in our testimony that I guess we would suggest is that this measure seeks to allow a premature bringing of an action under HRS 4035, otherwise known as making a payment under protest. Right now, the payment under protest statute requires the filing of an action within 30 days of the payment. And so what is being proposed in the measure is that if an action is brought prematurely and a court dismisses the case, the payment could be held by the state, and then once the agency makes a final decision, the action can be refiled. But the measure says that the action can be refiled within 2 years. And so our recommendation is to make it 30 days, to make it consistent with the current statute. We're not aware of any reason why the filing of a premature action under this statute should have 2 years, when someone who files and does it timely only has 30 days.
Okay.
Thank you.
Thanks very much. And we have testimony from Tom Yamachika, Tax Foundation of Hawaii.
Thank you, Chair, Vice Chair, members of the committee. Tom Yamachika from Tax Foundation of Hawaii. The reason why this bill is being presented is because there have been situations that have come up where the taxpayer, through I think no fault of their own, is told by the tax department, like for example, they get an email from the auditor saying, well, our position is this, boom. And thinking that is an agency decision, they then file a payment under protest, only to be told that, that was just an email from the auditor. It doesn't count. The court then dismisses the lawsuit, and then the question is, does that mean that the tax department gets to keep the money without any adjudication on the merits? We kind of think it's unfair if they do, that we should at least have a chance for the court to speak to the merits of the issue before the taxpayer forfeits the money. So that is why this bill is being presented. I'd be happy to answer any questions that the committee members may have.
Thank you very much. Is there anyone else wishing to testify on HB 1805? If not, questions, members? Seeing none, let's move on to the last measure on our agenda. Thanks for everyone's patience. HB 1942, related to corporations. This permits real property assets of a dissolved corporation to escheat to the state if a creditor, claimant, or shareholder of the corporation cannot be found. Real property taxes and any state tax liens have remained unpaid for 5 years, and the state makes a showing that attempts to locate creditors, claimants, and shareholders of the dissolved corporation have been unsuccessful. First up, testimony in opposition from the Department of Land and Natural Resources.
Good afternoon, Chair Tarnas and members of the committee. Ian Hirokawa with DLNR. I'll just stand on the department's testimony in opposition and be available for any questions. Thank you.
Thank you, Mr. Hirokawa. Next, we have testimony support from Robbie Salmson, the Marcus Property Management, LLC, and testimony and support from Logan Freitas, Janice Chun, Sharon DaCosta, and Anthony Pitt. Is there anyone else wishing to testify on HB 1942? If not, questions, members? Real quick question, Ian. if we were to add to this bill that would have to be upon land board approval, would that work for the department? Since that's the main thing, is you want to have that review and determine whether or not you want to accept the property?
Well, I think if it preserves land board discretion, yeah, I don't know though who, I guess my question would be though, who would, like if the state, if there's this property that meets the criteria, and the state, I'm not sure who in the state is going to sort of bring this to the land board to say, okay, we have this eligible property, land board, will you please?
Good question, and I think if this committee decides to move it forward, that's a good question for the next committee.
And I think too, we'd also, maybe in these cases, with a lot of our acquisitions, they're sort of planned by the department or other agencies, so they provide funding to do things like due diligence, and
Understood.
getting the environmental studies. So, if we had to kind of like, if an agency says, oh, here's this property, right, and can you take it? It's gonna affect our finances, right, to have to do all these, like title report if possible, or.
I understand there's.
Environmental study, yeah. So that's, I guess, another concern, maybe beyond just simple land board approval,
Good point, good point. So I think if the committee decides to move it forward, then these are good questions for the next committee. Any other questions, members? If not, thank you, Ian, for your patience, and.
Oh, thank you.
If there's no more questions, let's move back up to the top of the Judiciary and Hawaiian Affairs agenda and do decision-making. First up, House Bill 1596. I recommend that we pass out an amended version, HD1, with technical amendments, defect the effective date to the year 3000. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1596 with amendments, Chair and Vice Chair vote aye. Representative Evslin?
Aye.
Representative Ganadin?
Aye.
Representative Holt? Excused. Representative Ichiyama?
Aye.
Representative Ilagan? Excused. Representative Kong?
No.
Representative Miyake?
Aye.
Representative Souza?
Aye.
Chair, your recommendation is adopted.
Thanks. Next is House Bill 1595. Thanks. I crossed out the number. Okay, House Bill 1595. I'd like to recommend we pass out an amended version of the bill, HD1. Change misdemeanor to petty misdemeanor on page 3, line 5. Remove Part 5 and defect the effective date to year 3000, make technical amendments. In the committee report, I'd like to suggest that that we also work to align this measure with Act 159, which takes effect on July 1st, 2025. But I want to keep the defective effective date at year 3000, so that's why I want to put it into the committee report. So that's my recommendation for this measure. Questions or concerns, members? Yes, Representative Gannon.
I'll try to be brief. Thank you, Chair, for hearing these bills discussing expungement, and thank you for all who testified. I think it's clear that the legislature, through these bills as well as Act 159, intends to expand those who are eligible for expungement and expedite the process for expungement. And it looks like we have a long way to go in supporting the Office of the Attorney General and the judiciary in those processes, whether that be through funding or some other process. I understand that we're the last committee to hear it, so we might not be able to touch this again for another few months. But that doesn't mean that the Office of the Attorney General, the judiciary, or other members of government can't work with us in the meantime. Thank you.
Thank you. And we are defecting the effective date to year 3000, so we'll make sure we will see this again. Any other questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1595, noting the presence of Representative Ilagan and the excused absence of Representative Holt. Anyone voting with reservations or no?
With reservations.
Reservations for Representative Kong. Chair, your recommendation is adopted.
Thank you. On this next measure, HB 1663, for now, I would recommend that we defer this measure. We need to move, we need to make progress on expungement in the state, and this is a step too far just at this time. But I will continue the emphasis of this committee on expungement. And I will note that we are intending to organize an information briefing on expungement on March 1st. So this committee will continue the discussions on this matter and try to bring together all the organizations and institutions within the state that are working on this to find a path forward. Next, House Bill 2513. On this measure, I would like to move it out with an amendment, HD1. I would like to take the AG's amendments and the Department of Transportation's amendments, defect the effective date to the year 3000, and that's it. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 2513 with amendments. Anyone voting with reservations or no? Chair, your recommendation is adopted.
You are good. Okay, next, on to the tax measures. HB 1806, I recommend that we pass that on HD1, defect the effective date to year 3000, and pass it out. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1806 with amendments. Anyone voting with reservations or no? Chair, your recommendation is adopted.
Thank you. Next, I want to recommend we pass out an HD1, defect the effective date to year 3000, and pass it out. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 2485 with amendments. Anyone with reservations or voting no? Your recommendation is adopted.
Thank you. HB 2486, recommend passing out an HD1, defect the effective date to 3000, and pass it out. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 2486 with amendments. Anyone voting with reservations or no? Seeing none, your recommendation is adopted.
Thank you. Next measure, 2487. This needs work. I would recommend that we defer this measure, and I would recommend to the department that you use the Senate version, Senate Bill 3176, which has a Ways and Means / Judiciary referral, so it's one committee. Work with them on that, because it needs work. And I'm not going to be able to put the work into it now, and I don't want to put it on finance. So I'm recommending we defer this measure here. So work with your Senate. Next one, 2488. Recommend that we defect the effective date to the year 3000 and pass it out. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 2488 with amendments. Anyone voting with reservations or no? Seeing none, your recommendation is adopted.
Thank you. Next measure, 1805. This one, I want to defect the effective date to year 3000 and include in the committee report the request to finance that they need to address the testimony and the concerns from the Department of Taxation, because I think that's more in their kuleana than mine. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1805 with amendments. Anyone voting with reservations or no? Your recommendation is adopted.
Thank you. Final bill, HB 1942. I recommend we pass out a House Draft 1, defect the effective date to year 3000, and put in there that it would only be able, that the state would not accept it unless there's land board approval. The state would not accept the property unless there's land board approval. And I would include in the committee report that I recommend the next committee address the concerns from the department about potential fiscal impacts. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 1942 with amendments. Anyone voting with reservations or no? Your recommendation is adopted.
Thank you very much. There being no further business for this committee, we are adjourned.